I am Dr. Ricardo Pereira, and I'm a reader in law, or as also known in continental Europe and other jurisdictions, associate professor in law here at Cardiff University Law and Politics School, where I teach and conduct research in the fields of international and European law, energy law, environmental law, human rights, and international economic law. I am the convener of the workshop on corporate accountability for human rights abuses and natural resources governance, a study in global law, development, and justice, which will take place across the next 2 days, so today and tomorrow. The topic of this conference could not be more topical and relevant. We continue to witness countless examples across the world of widespread human rights violations by companies, in particular multinational and extractive companies, which result in major negative impacts on the environment and the livelihoods of communities. This includes land grabs, forced evictions, illegal natural resources exploitation, significant pollution and environmental damage, labor exploitation, tax evasion and avoidance, among other human rights abuses. Yet there are examples of best practice that we can draw upon, including projects that have integrated public and indigenous participation in project development. Human rights standards are integrated into environmental impact assessments and post-licensing monitoring of projects, and of companies that are implementing human rights due diligence obligations in their operations. We are very well placed by bringing together an outstanding group of scholars and practitioners from all over the world to fulfill these workshop central objectives, which are to critically examine the role played by international, regional, and national institutions in holding corporations, in particular multinational corporations, effectively accountable for human rights violations in light of the imperatives of social and ecological justice and intergenerational equity. To provide a contextualized and critical analysis of developments in business and human rights and natural resources law and governance, with reference to case studies in natural resources governance in selected countries and regions, particularly in the global south, Africa, Asia, and Latin America. And our final aim is to propose a global legal framework for the liability of and law enforcement against corporate groups, both parent companies and subsidiaries, and their directors, employees, managers, and shareholders for human rights abuses arising from their operations in the global south, taking account of the existing initiatives and human rights standards such as the UN Global Compact, the OECD guidelines on multinational corporate enterprises, the UN guiding principles on business and human rights, and the work of the late former UN Special Representative on Business and Human Rights, John Rogin, and also the ongoing negotiations of the UN Draft Business and Human Rights Treaty, also known as the legally binding instrument to regulate in international human rights law the activities of transnational corporations and other business enterprises. Now I'd like to proceed with a few acknowledgements and announcements concerning the proceedings. Firstly and foremost, I must thank all the speakers of this conference who are renowned scholars and practitioners working in the fields of business and human rights, natural resources law, and transnational law. I must thank our 3 keynote speakers, Professor Penelope Simons, Chair, the Gordon Henderson, Chair in Human Rights, and Vice Dean for Research at the Faculty of Law, the Common Law section at the University of Ottawa, who will be delivering the opening keynote speech to this conference today. I must thank Professor Jeremy Gilbert, Professor of Human Rights Law at the University of Roehampton, who will be delivering this evening's keynote speech, and Professor Damilola Olawuyi-Sun, who's a professor of petroleum, energy, and environmental law at the Hamad bin Khalifa University Law College, Qatar, and Chancellor's Fellow at the Institute for Oil, Gas, Energy, Environment, and Sustainable Development at Babalola University, Ado Ekiti, Nigeria, who will be delivering the closing keynote speech to our conference tomorrow. The strength of their scholarly contributions, advocacy, and practice in advancing the integration of human rights standards in natural resources governance is unparalleled. And it's an honor to have them join us and share their expertise with us in this conference. I must thank each of my colleagues at Cardiff University who will be acting as chairs and moderating the panel and keynote speeches both today and tomorrow. I would like to thank Dr. Ivano Alonia, Arthur Watts Research Fellow in Environmental and Climate Change Law at the British Institute of International and Comparative Law for Pickle in London, for joining us and chairing panel 2 today. This workshop is organized under the framework of the Center for Human Rights and Public Law at Cardiff Law and Politics School. The Center for Human Rights and Public Law was established in the School of Law and Politics in 2011. The center aims to provide teaching and research in human rights and public law. The center brings together members of the School of Law and Politics with expertise in both international and domestic law, and provides a forum for dissemination of research. The center members are involved in research-led teaching on the school's undergraduate programs in the fields of human rights and public law. I must thank the center's director, Dr. Bernadette Raines, at the School of Law and Politics here at Cardiff, for her leadership of the center. And she will be with us acting as the chair of panel 4 tomorrow. I must thank the workshop's funder, the Learned Society of Wales, which has made the organization of this online event possible. The Learned Society of Wales is the National Academy for Arts and Sciences. The Society's fellowship brings together experts from across all academic fields and beyond. The Society uses this collective knowledge to provide research, inspire learning, and provide independent policy advice. I should also add that this event has benefited from internal funding, originally from our Center of Law and Society here at the Cardiff Law and School of Politics. Before, as many of the workshop participants will know, the very unfortunate need to cancel in what would have been an in-person version of this event due to the pandemic. And subsequently by another internal funding opportunity provided by the Law and School and Politics Research Support Scheme for what is now an online version of this conference. I would like to thank the European Center for Constitutional and Human Rights in Berlin for partnering with us in the delivery of this workshop. The EECHR is an independent, non-profit, legal and educational organization dedicated to enforcing civil and human rights worldwide and is based in Berlin. I look forward to listening to Canel Levitt and Laura Duarte Reyes' presentation in panel 2 today, in which they will be giving us an insight into the EECCHR's crucial work in bringing corporations, including extractive companies, to account for human rights abuses. Finally, I must thank the members of the student body here at Cardiff University who have joined the organizing committee for this conference. PhD candidate Abdulrahman Goren and LLM candidates Vanessa Lucasa and Joe Maloney. On a note, I will hand over the floor to my colleague, Professor Valerie Fogelman, who will introduce herself and our opening keynote speaker, and I'll swiftly disappear in the background for now. Thank you very much.
Thank you very much. I have the honor of introducing the keynote speaker, Professor Penelope Simons. She is, as Dr. Pereiro mentioned, a professor at the Faculty of Law of the University of Ottawa, the Gordon F. Henderson Chair in Human Rights, and the Vice Dean of Research. Importantly, though, for this workshop, she's a global leader in domestic and transnational business activities and human rights. Her research focuses in particular on the governance of natural resource extraction by domestic and transnational corporations and how best it can be regulated to protect human rights, especially the protection of women from sexual and other types of violence. Professor Simons has an unparalleled knowledge of natural resource extraction and human rights. This has been aided by her background as a practitioner in corporate and commercial law, also being a member of a Canadian government mission to investigate allegations of slavery in Sudan and detailed knowledge of human rights abuses throughout the world, including Papua New Guinea, Honduras, and Guatemala. It's my honor and my very great pleasure to introduce Professor Simons and to ask her to give the keynote speech entitled Human Rights and Natural Resource Governance, Looking Back and Looking Forward. And just very quickly, if anybody's got any questions, which I hope they will, if you could just post them on the chat box, please. Thank you.
Thank you very much, Professor Fogelman, for that introduction, and also for Dr. Pereira for inviting me to speak to you today. It's really an honor to be here at this really important workshop. And I want to begin by recognizing that I'm speaking to you from unceded Algonquin territory in which the city of Ottawa is located. Sundia Pahuja and Anne Saunders, in their book chapter, Rival Worlds and the Place of the Corporation in International Law, engage in a retelling of the struggles of the third world states in seeking a new international economic order to establish an international legal response to the regulation of powerful, shape-shifting, profit-seeking business actors, including Western extractive companies. What they remind us is that the story of the need to regulate business actors and how to do it best, it has a very long history that has had several iterations. And I'll be focusing on some developments in knowledge and governance, although not litigation, over the last decades, and some challenges that we face going forward. All of us who study and write about and advocate for better governance and accountability of extractive companies came to this issue in different ways. And as Professor Fogelman mentioned, my introduction to it was in 1999 when I was asked to participate in an independent mission sent by the Government of Canada to Sudan to investigate allegations of grave human rights violations that were being perpetrated in the oil fields where a Canadian company, Talisman Energy, was operating as part of the joint venture. Reports had come out of Sudan in the late 1990s from NGOs that were operating in the field, and also from the UN Special Rapporteur on Sudan about scorched earth tactics that were being employed by the government of Sudan forces and other militia in the course of allegedly protecting the oil installations, pipeline, and development areas from rebel attacks. During our 3-week visit to Sudan, we talked with many people who had suffered inconceivable abuses that were being perpetrated by Sudanese forces and government-sponsored militia. Many of these people had fled their homes with barely the clothes on their back and only children they could carry. Many thought our presence there was going to bring about some change, that we would be able to help them. Some of them died during the conflict of starvation, dehydration, malaria, and other effects of forced displacement. And some were killed in air raids, and some were brutally raped or murdered by ground troops. Some survived and were able to return home, and some continue to live with conflict and insecurity because of ongoing extraction and development of oil. This experience in Sudan really changed me, and it shaped my academic research for the last 2 decades. I've never been able to forget one question that was asked by one of the women that we spoke to. Why are we not included in the human rights of the world? Now, of course, in those days, voluntary self-regulation was the only accepted means of governance, and corporations and the people behind them operated with virtual impunity for human rights violations they perpetrated or in which they were complicit. The people who were the victims of these egregious abuses that I've described never received any reparations, and despite being tied up in litigation over its Sudan operations for 9 years in the US courts, neither Talisman nor its executives were ever held accountable for their complicity in those terrible abuses. The company went on to reinvent itself, as many companies do, and it became a Canadian poster child for corporate social responsibility. It engaged with the mandate of the Special Representative on Business and Human Rights, John Ruggie, and also engaged in many domestic and global dialogues and processes that sought to regulate Canadian extractives and other companies. Concerns about the human rights implications of resource extraction, and particularly transnational resource extraction and corporate impunity, have helped to shape the beginnings of business and human rights as a field of academic research, but also as a social movement. If you look at the Business and Human Rights Resource Center website, it's actually astounding the range of different industries and sectors that are represented there that have been implicated in human rights violations. And it's really heartening for me to see, as I mentioned to Ricardo before the conference, to see a conference that's been dedicated to resource extraction and governance issues. And in my view, it remains crucial to continue to focus on resource extraction for a number of reasons. Extractive companies go where the resources are, so they're more likely to end up in areas of conflict or repressive regimes or otherwise weak governance zones. And so they're more likely than other industries to perpetrate or become complicit in violations of human rights. As all of you know who work in this area, the human rights abuses associated with resource extraction often rank among the most egregious. And violence against human rights defenders that relates to resource extraction is on the rise. In 2021, the Business and Human Rights Resource Center recorded 156 attacks globally that are associated with mining activity and 75 associated with oil, gas, and coal extraction. This is the highest annual number since the Business and Human Rights Resource Center started keeping track of these attacks. Now, even where corporations operate in democratic states or non-conflict affected areas, and even if they put in place responsible business conduct policies and process, the nature of resource extractive activity means that it is going to have impacts, often negative, on the land rights and resources of local communities, including those of Indigenous peoples. They might be operating or proposing to invest where there is pre-existing social or political conflict over land, or where the concessions have been granted in a manner that violates Indigenous people's rights to free, prior, and informed consent. Their activities might also exacerbate existing local tensions or create new tensions or conflict where part of a community opposes the extraction or there are different communities that are differently impacted. Despite the fact that resource extraction makes up only 10% of global FDI, extractive companies have consistently been the subject of a considerable proportion of the allegations of wrongdoing that are made against corporations. And they've also been the defendants in many and most of the transnational civil suits that are brought against transnational corporations. And finally, the governance of extractive activity, and I'll come back to this at the end, matters tremendously to the necessary transformations that we have to make to address and adapt to climate change. So let's talk a little bit about some progress over the past 2 decades. I think in terms of knowledge, we understand a lot more about some of the structural factors that make regulatory action challenging, but not impossible. And let me just mention a few. It's very widely recognized now that corporations are the beneficiaries of robust protections provided by trade and investment law, as well as the impact of interventions by international financial institutions, which together have undermined states' regulatory capacity. And this awareness was certainly not the case in the early 2000s. Thanks to several generations of Twale scholars and others, there's a much better understanding of the biased structure of the international legal system and its entrenchment of global economic power relations through the regulated and unregulated spaces that it generates and sustains. Feminist international law scholars have examined and exposed the patriarchal and often misogynistic nature of the international legal system. And many business and human rights interventions on gender have exposed or helped to confirm perhaps the breadth and the depth of the androcentricity of the international legal system, including its relationship with domestic law. For example, by drawing attention to the peripheral place of women, persons of diverse genders, and other marginalized persons in the consciousness of the actors and institutions that develop business and human rights norms. We're also starting to better understand the differentiated impacts of resource extraction on women, including Indigenous women, such as the heightened risk of gendered intersectional violence women face, whether as employees of extractive companies or through the increase in domestic violence that extractive activity brings, or as members of local communities that are affected by extraction, where rape may be used to silence women human rights defenders, or as an intimidation tactic of security forces, or simply because an extractive worker was high or drunk and wanted sex. There is more and more evidence about the devastating impacts of resource extraction on Indigenous peoples, the violence they suffer at the hands of security forces or through displacement, environmental degradation, and contamination of land, water, and the flora and fauna that affects their ability to live off the land, affects their way of life, and affects their ability to engage in their sacred rituals, among other things. Now, there has been significant normative development since the early 2000s when the UN draft norms created such a firestorm and then were set aside by the UN Special Representative on Business and Human Rights. The development and strong endorsement in 2011 of the UN Guiding Principles by the Human Rights Council has helped to shape the discourse about the obligations of states and the appropriate responsibilities of business actors. And despite the many flaws of the Guiding Principles, they have provided a standard that civil society actors and others can use to hold governments to account for their failures in protecting human rights and to call for change. They also set a benchmark for calling on corporations to respect human rights and to engage in human rights due diligence. And the concept of human rights due diligence has been embraced by states and even business actors. The struggle to convince governments to take regulatory action and not simply play lip service to it has been a long, slow, and often disheartening process. And in many ways, the UNGPs and John Ruggie's views about law and legalization of the UN Guiding Principles has helped to undermine this aspiration. But compared to the early 2000s, there is a much more widely held view beyond communities, beyond civil society, and beyond academia on the need for law at the domestic, supranational, regional, and international levels. And this is reflective, of course, in the fact that many states from the Global South sponsored the resolution, the controversial resolution in the Human Rights Council to initiate the Business and Human Rights Treaty process. And the fact that, despite the fact it being controversial, that we have a zero draft of the treaty that deals with prevention, effective remedy, and criminal sanctions. We are now seeing also a proliferation of mandatory human rights due diligence laws in European states like France, Germany, the Netherlands, and also a proposal that's being put forward at the EU level for a directive. And if anybody had told me 8 years ago that states in the global north would be implementing mandatory human rights legislation and that we would have a zero draft of the treaty text, I would definitely not have believed them. While recognizing this important progress in lawmaking and norm development to address corporate impunity, we also need to look at some of the problems and gaps in these initiatives. The guiding principles, as I mentioned before, were widely criticized on a number of fronts, and I don't want to reiterate all of those criticisms. I'm just going to mention a couple that have become more relevant now. First of all, they inadequately protect women's human rights in the context of business activity and arguably reproduce the androcentric bias of traditional international human rights law. And importantly, they fail to include the rights of communities who are central stakeholders in business and human rights governance. The working group, of course, has done important work to interpret state obligations and business responsibilities on a number of issues. At the same time, the text of the guiding principles has meant that they have not laid sufficient groundwork for the development of more inclusive and effective norms of home state obligations and business responsibilities and effective remedy for victims. There are also significant gaps in human rights due diligence laws, and there have been, for example, a litany of critiques of the EC, the European Commission proposal for a directive. I'll just mention a few of them. First of all, the scope, it covers only very large companies, with 500 employees and 150 million euros in turnover. It also covers smaller sort of high impact industries like in the extractive sector with 250 employees and 40 million euros turnover. However, if the proposal is enacted as set out now, those smaller extractive companies will only need to address actual or potential severe impacts and not other impacts. Human rights due diligence obligations also only apply to established business relationships. There's no due diligence obligation related to the reduction of greenhouse gases. The the proposal says nothing about gender, despite significant input from feminist organizations. And in fact, surprisingly, the third revised draft of the treaty is more progressive than the proposal on this issue. The proposal also doesn't adequately address business activity and conflict. There's no mention, for example, of security provider management, as has been pointed out by Voilat and Reynolds. Another problem is that while mandatory human rights due diligence is crucial, it's really only part of the picture. We need much more comprehensive legislation that sets out a range of effective facilitative and coercive and incentive mechanism, and includes judicial and non-judicial remedies, but is much more comprehensive. And I'll say a few words about that later. With respect to the treaty, the political viability of the treaty process is still unclear, and the treaty itself is fairly narrow in scope, focusing mostly on state obligations with respect to requiring human rights due diligence and then access to effective remedies. While the EU, after obstructing the process, has now stated it is committed to engaging with it, and we'll see how that goes, states with big extractive industries like the US, Canada, and Australia have so far not engaged with this process. And finally, all of these norms that we've discussed are deeply enmeshed with and designed to function within the neoliberal capitalist system. Linarelli and Salomon and Sonaraja, in their book, The Misery of International Law, have described global capitalism as a grossly disempowering system that has both failed to benefit most people and created a huge alienated transnational class in the process, the latter being considered an indispensable necessity. Global capitalism is propped up by the international legal system, which has enabled and protected business activity, resulting in the establishment of a market-friendly international order that enriches a few, in the words of Linarelli and Salomon and Sonaraja, at the expense of everyone else, wrongs women with particular efficiency, and is environmentally destructive and unsustainable. The UNGPs, the mandatory human rights due diligence laws, and the business and human rights treaties are essentially designed to facilitate business activity while putting some restrictions on it with respect to resource extraction, and none of them contemplate no-go zones. The concept of human rights due diligence is all about putting in place a process that will generally allow business activity to go forward. None of these norms sufficiently address the problems posed by complex corporate structures and the doctrines of separate legal personality and limited liability. All of them fail adequately to address the gendered, racist, heteronormative, ableist, and other structures that oppress women, persons of diverse genders, Indigenous people, other racialized persons, and persons with disabilities, among others. There are still ongoing battles in major resource extraction states to enact and implement meaningful governance over their extractive industries and to put in place effective remedies. And of course, Canada, where I'm from, is a salient example. As you know, it is a giant with respect to resource extraction. Canadian companies have been implicated in hundreds and hundreds of human rights violations in their overseas operations. And in fact, a 2020 study that examined 2,700 environmental conflicts between companies and communities showed that Canadian extractive companies were implicated in over 8% of those conflicts, many more than their peers. There have been calls from civil society actors, academics, treaty bodies, MPs, our own Standing Committee on Foreign Affairs and International Trade, for Canada to enact laws to effectively govern our transnational extractive activity. And the Canadian Network on Corporate Accountability, which is an umbrella NGO organization, has developed model legislation on mandatory human rights due diligence, which it launched last year. And the government has so far ignored it. And in fact, 2 weeks ago, it released its latest policy on responsible business conduct abroad. Now, it is a little better than the previous policy. It's less vague. It sets out clearer expectations for corporations to operate consistently with the guiding principles in the OECD guidelines. But the policy remains based on self-regulation, with the focus ensuring on the global competitiveness of Canadian companies and the risks to companies rather than to individuals and communities. It also relies on weak oversight mechanisms and two very flawed non-judicial remedy mechanisms. One is the Canadian National Contact Point, which I won't speak about. The second is the Canadian Ombudsperson for Responsible Enterprise, and I'll say a few words about that. Now, this is something that has been fought for over 2 decades, to have a credible independent complaints mechanism for those who've had their rights violated by Canadian extractive companies abroad. And the government promised in establishing the ombudsperson that that's exactly what they would do. They would give this ombudsperson powers to compel witnesses and documents so that it could effectively investigate allegations that were brought to it. However, there was a big 15-month delay between the announcement and the establishment of this ombudsperson, and there was a change of ministers in between, and industry associations were able to lobby hard for a weakened mechanism. And in December 2020, the new minister in charge, the Minister of Small Business, Export Development and International Trade, announced it wouldn't be endowing the ombudsperson with these powers. Now, at the end of March, 2 private members' bills were tabled by MPs in our federal parliament that, if enacted, would give the ombudsperson the power to compel witnesses and documents, and the other one would impose mandatory human rights due diligence on Canadian companies operating transnationally. Now, the political viability of those bills, of course, is still unknown. Like many countries, Canada provides significant supports to extractive companies operating at home and abroad without much regard to the behavior of those companies. Extractive companies raise billions of dollars on Canadian stock exchanges. Our pension plans invest in the extractive sector. Trade missions, trade advocacy is undertaken to support and promote and advocate for business activity abroad. Our export credit agency supports the extractive industry with a variety of ways of funding them. And without much, even though they have a new human rights policy, there still is not much regard to what those companies have been involved in or the impacts of those projects. Amnesty International has pointed out that our extractive export credit agency is one of the biggest public financial backers of fossil fuels in the world. It provides tens of billions of dollars to support oil and gas development. And also, like many other countries, Canada negotiates international investment agreements, especially with countries where Canadian extractives operate. And despite engaging in consultations to reimagine the model agreements that we use, they ended up making no radical changes to the latest version and only pay lip service to responsible business conduct. The Intergovernmental Panel on Climate Change have been issuing urgent and formidable warnings that we need to fundamentally change how we live in order to prevent catastrophic global warming. In other words, we can no longer do business as usual, both figuratively and literally. To attain this goal and to adapt to by transitioning to high well-being and low carbon demand societies, we need, they say, to engage in rapid and far-reaching transitions in energy, land, urban infrastructure, and industrial systems. Now, the Intergovernmental Panel has also noted that in achieving this goal, we also need to engage in sustainable development that supports and enables the fundamental societal systems and transitions and transformations that help to limit global warming. Social justice and equity, it says, are core aspects of climate resilient development pathways. They address challenges and inevitable trade-offs, widen opportunities, ensure that options, visions, and values are deliberated between and within countries and communities without making the poor and disadvantaged worse off. Of course, extractive industries are deeply implicated directly in climate change, forestry, oil, gas, coal, and some mining. But they also continue to operate unsustainably through their impacts on the environment and on the human rights of the communities in which they operate. So let me conclude with a few observations. At this crucial time when we face this existential crisis, unfortunately, our politicians are distracted by the war in Ukraine and its impacts on access to fossil fuels, and by the cultural wars and regressive politics that are playing out across the globe. At the same time, we have no choice but to take action to address climate change, and how we deal with the governance of resource extraction will be crucial to our success. This change needs to be bold, creative, and radical. Neoliberal capitalism is based on this idea of ever-increasing markets and productions, and at some point, we need our politicians to start asking how much is enough. Instead of seeking to meet ever-increasing energy needs, we need to reduce our energy needs. We need to reimagine the global and domestic economy and look for alternatives to neoliberal ways of doing things. If social justice and equity are core aspects of climate resilient development pathways, then we must take seriously the human rights implications of extractive activities at home and abroad. A clean energy transition will require continued extractive activity. But for resource extraction to be sustainable, if it can be, people cannot be dispossessed of their lands, killed or criminalized for protecting them, or have their food sources and livelihoods and health ruined by toxic waste and toxic runoff. The Intergovernmental Panel on Climate Change has noted that a major shift is required in decision-making process in the direction of taking a holistic view, developing institutional mechanisms to coordinate the actions of diverse actors and strengthening complementarities and synergies. And this includes the governance of resource extraction. We need to move beyond this narrow focus of human rights due diligence towards comprehensive, inclusive regulatory frameworks at international and domestic law levels to prevent extractive companies becoming involved in human rights violations and to hold them accountable and provide effective remedies. We need to reimagine the corporation, its purpose and its bottom line. We need legislative changes to address the obligations of government agencies that support and facilitate extractive companies. We need incentive mechanisms, those that leverage the full panoply of ways in which the government supports business abroad, including through international investment agreements. We need facilitative mechanisms that allow private actors to challenge corporate conduct, to seek redress in domestic courts without encountering jurisdiction and other hurdles, legal obstacles. We need coercive mechanisms such as criminal sanctions for the most egregious conduct, and we need capital market sanctions. We need policy coherence, development assistance policy, trade and investment policy, international human rights and environmental policy. All of them must be coherent, and all of them must address the issue of corporate accountability for human rights violations. We need all states, and particularly those that are home to powerful extractive companies, to participate in good faith in the business and human rights treaties negotiations. These are big changes and they will be challenging, and we also need other ones that are more creative and more radical. Change requires inevitable trade-offs. We can't continue to treat profit as more important than human rights and social justice, and to run our economies on the backs of those from other countries, or in the case of Canada, on the backs of Indigenous communities at home. Pahuja and Saunders have stated that much that was at stake during the 1950s and 70s remains so today, and that as long as another vision is imaginable, other worlds are still possible. And I look forward to hearing about these different visions today and tomorrow. Thank you very much.
All right. Well, it's just two. So I guess I will commence this first panel, which is entitled Contextualizing Corporate Human Rights Abuses in Natural Resource Governance, Actors, Conflicts, and Accountability in Peace-Building Processes. It's a bit of a mouthful, but, it's about looking at abuses and natural resource governance and how do we find accountability for these things? I should introduce myself. My name is Dr. Caleb Wheeler. I'm a lecturer of law at Cardiff University. My area of research is slightly adjunct to this. It's international criminal law, but I've done research on the role of corporations in international criminal law, ways of finding accountability in that context. And so this is a topic I'm very interested in and very interested in learning more about. I won't talk too much about myself. None of you came here to hear me speak, which is fine. I certainly understand. But we have two excellent panelists today. The first is Dr. Daniela Dam de Jong. Dr. Dam de Jong is an associate professor at Leiden University, and the director of the LLM regular program at the Grotius Center for International Legal Studies. Dr. Dom de Jong has done considerable research into environmental exploitation and protection during armed conflicts, as well as the need to hold corporations accountable for their environmental harms. So very much hitting on all of the hot topics of this panel. The paper today, as I understand it, is going to be called "Business as Usual: Conceptualizations of Corporate Accountability in Peace Processes." So thank you for joining us, and I'll turn it over to you.
So thank you very much for this kind introduction, Caleb Wheeler, and also to Rico Pereira for inviting me to this very interesting event and to exchange views with others. And the last word of thanks also to Professor Simons for giving this excellent tour d'horizon, showing us what has already been achieved over the past decades, but also showing us what we still need to do, which is quite daunting, to be honest. So my presentation today focuses on conceptualizations of corporate accountability in peace processes. So natural resources are associated with the onset, the fueling, and the financing of armed conflicts. And according to several studies by the UN and the World Bank, more than 40% of internal armed conflicts over the past 60 years have been linked to natural resources, with mismanagement and inequitable distribution among the key drivers for such conflicts. And to provide some examples, inequitable land distribution and land grabbing were at the root of several armed conflicts in the second half of the 20th century. Examples include the conflicts in Guatemala and in Colombia, while Cambodia serves as an example of such practices in the aftermath of armed conflict. And the trafficking of minerals and other high-value natural resources have financed many armed conflicts between the 1990s and today, notably in Africa. So these practices have a clear economic dimension, which it brings into play the contribution of corporations to causing and sustaining armed conflicts. So this presentation zooms in on the conceptualization of accountability for corporations in peace processes. Corporate accountability is an aspect that is often neglected in such processes. To the extent that peace processes address past wrongs, the focus is predominantly on atrocities committed by the main conflict protagonists. This is highly problematic because by omitting to address the role of economic actors in facilitating or benefiting from such atrocities, the message that is conveyed to corporations is that they can simply continue to conduct business as usual. This presentation will discuss two very different mechanisms that have been developed as part of peace processes, namely truth and reconciliation commissions on the one hand, and regulatory mechanisms aimed at stopping the trade in conflict resources on the other. Where the principal purpose of truth and reconciliation commissions is to look back and to draw lessons from the past, regulatory mechanisms look forward, aiming to influence future behavior. These different goals arguably have an impact on how these mechanisms conceptualize accountability. But before I move on to the substantive discussion, I feel that it would be useful to briefly pause and to explore what we mean by accountability in the first place. So this workshop aims to, and I quote, critically examine the role played by international, regional, and national institutions in holding corporations effectively accountable for violations of human rights law. So accountability as a notion is, however, broader. Curtin and Nolkamper, for instance, distinguish between giving account and holding to account. In their perspective, giving account refers to the act of disclosing information and justifying behavior against particular norms or standards. Holding to account, on the other hand, is defined as, and I quote, a process in which an actor not only explains conduct and gives information to others, but one in which a judgment or assessment of that conduct is rendered on the basis of prior established rules or principles, and in which it may be possible for some form of sanction, formal or informal, to be imposed on the actor, end of quote. This form of accountability includes the possibility for an external actor to assess whether the actions of the duty bearers violate the rules or standards, and to attach consequences to the violations. This distinction between giving account and holding to account builds on the work of Mark Bovens, one of the leading authorities on accountability. According to him, accountability is both a mechanism and a virtue. As a mechanism, accountability can be defined as, and I quote Bovens, a relationship between an actor and a form in which the actor has an obligation to explain and to justify his or her conduct. The form can pose questions and pose judgment, and the actor may face consequences. Most importantly, the definition emphasizes that accountability is a, and I quote, relational concept, linked to those who owe an account, to those to whom it is owed, end of quote. So this is basically what Curtin and Nolkemper call holding to account. Accountability is, however, also, again quoting Bovens, a normative concept, a set of standards for the evaluation of the behavior of public actors. This is what Bovens refers to as accountability as a virtue. Accountability in this sense focuses on substantive norms that define accountable behavior, and I would add, not just for public, but also for private actors. This conceptualization differs slightly from Curtin and Nolkemper's giving account, as accountability as a virtue focuses on the substantive norms themselves, while giving account refers to the act of explaining behavior. So in sum, accountability may refer to norms and standards that define accountable behavior. It may refer to the act of justifying behavior, giving account, and it may refer to the mechanisms for holding persons to account, accountability as a mechanism or holding to account. This distinction is useful for the purpose of understanding the way corporate accountability has been conceptualized in peace processes. So moving on to the substantive discussion. So how, in the first place, do Truth and Reconciliation Commissions conceptualize accountability? Business involvement in conflict-related human rights violations is a matter that is addressed in many truth and reconciliation processes. The Corporate Accountability and Transitional Justice Project, conducted by Oxford University and partners, found that 22 out of 39 truth commissions did in fact recognize business involvement in human rights violations in their final reports. However, it is far less common for such mechanisms to address economic violence, such as violations of economic, social, and cultural rights, corruption, and plunder of natural resources. There are some exceptions. 8 out of the 39 commissions addressed environmental or property matters, some of these concerning land dispossession. However, only 2 issued relevant recommendations, while only 1 such mechanism dealt specifically with these matters in connection to an armed conflict. This was the Liberian Truth and Reconciliation Commission, established pursuant to the 2003 Comprehensive Peace Agreement in Accra. In other words, while there is broader recognition of business involvement in human rights violations during armed conflicts, and while some of the commissions did in fact address environmental matters, the Liberian TRC is unique in addressing these matters in connection to an armed conflict. One of the reasons explaining the Liberian Commission's engagement with environmental matters is that it received an explicit mandate to do so. Pursuant to the act establishing the commission, it was mandated to investigate, and I quote, gross human rights violations and violations of international humanitarian law, as well as abuses that occurred, including economic crimes, such as the exploitation of natural or public resources to perpetuate armed conflicts, end of quote. It was furthermore mandated to determine, and I quote again, those responsible for the commission of the violations and abuses. In other words, the commission was both able to address economic crimes, such as the exploitation of natural resources, and it could pinpoint those responsible, including corporations. In its final report, the Commission indeed included recommendations to prosecute natural and legal persons for the commission of economic crimes, defined as, and I quote, any prohibited activity committed for the purpose of generating economic gain, or that in fact generates economic gain by persons and actors whose economic activities contributed to gross human rights and or humanitarian law violations in Liberia, or that otherwise perpetrated armed conflict in Liberia, as well as those who benefited economically from armed conflict in Liberia. The report was, however, not well received, either domestically or internationally. It was considered to be not sufficiently coherent or precise with respect to the evidence on which its conclusions relied. The recommendations relating to the prosecutions for economic crimes did not receive any follow-up either. The only accountability that was achieved was ultimately through the concession review procedure that Liberia and international partners established, but this procedure was already in place when the TRC released its final report. So to conclude this part, accountability in the context of the Liberian TRC was conceptualized as full accountability, including holding actors to account for their behavior. However, such accountability was never actually achieved, except to a limited extent in the concession review procedure, excluding those responsible for wrongdoing during the conflict from obtaining new concessions. Mention can also be made to the case that was instituted before the Dutch courts against Guus Kouwenhoven, the director of the Oriental Timber Company. However, he was prosecuted primarily for supplying arms to Charles Taylor and not for economic crimes directly. So moving on to regulatory mechanisms and how they conceptualize accountability. So the two best known mechanisms that have been developed to stop the trade in conflict resources are the Kimberley process for the certification of rough diamonds and the due diligence guidelines that were developed by the OECD, the UN group of experts on the DR Congo, and the International Conference for the Great Lakes region. Since only the second directly addresses corporations, I will zoom in on this mechanism. These due diligence guidelines were developed as part of the UN Security Council sanction regime on the DR Congo. Specific guidelines were developed for the DR Congo, but the OECD also developed more general guidelines for responsible supply chains of minerals from conflict-affected and high-risk areas, based on the Ruggie principles. The principal difference between the DR Congo guidelines and the OECD guidance is its geographical scope. In practice, the OECD guidance has become the main instrument for regulating corporations sourcing minerals from conflict regions. The purpose of the guidance is to prevent corporations which operate in or source from conflict-affected or high-risk areas from contributing to serious human rights abuses or international crimes associated with the extraction, transport, or trade in minerals, and to prevent corporations from providing any form of support to armed groups or from engaging in bribery and or fraudulent misrepresentation of minerals. In other words, the focus of the guidance is on prevention rather than on accountability. Its principal method for achieving this is due diligence, defined as, and I quote, an ongoing, proactive, and reactive process through which companies can ensure that they respect human rights and do not contribute to conflict, end of quote. The due diligence framework is further operationalized through a 5-step approach aimed at identifying and responding to risks in the supply chain. The basic components of this approach are the establishment of strong company management systems, the identification and assessment of supply chain risks, the design and implementation of strategies to respond to identified risks, the performance of independent third-party audits, and the annual reporting on supply chain due diligence. The focus of the due diligence assessment is therefore on acquiring and disclosing information regarding the source of the minerals procured by corporations throughout the supply chain, from the mine to the end products. In other words, the focus is on standards, accountability as a virtue, and on giving account. However, arguably, the guidance has an important role to play in promoting accountability. By setting requirements for corporations to verify the sources of the minerals that they procured, the guidance mandates corporations to establish a documentary trail. This in itself provides a good basis for holding corporations accountable for a failure to conduct adequate due diligence. As such, it provides a good basis for courts to assess corporations' behavior. Of course, a major weakness of the guidance is that it is not mandatory. At the same time, due diligence requirements for corporations based on those of the OECD guidance, as was already flagged, are increasingly incorporated in domestic legislation. The EU conflict minerals regulation is a good example, but even more important are the more general due diligence laws that are currently developed in a number of countries, including in the EU. To conclude, This presentation has discussed two very different mechanisms developed in relation to peace processes, looking at how accountability is conceptualized within these mechanisms. Of course, comparing truth and reconciliation commissions with regulatory mechanisms is comparing apples with pears. The objectives of these mechanisms are in no way comparable. However, what they do have in common is that both ultimately create the conditions for external mechanisms to hold corporations to account. Personally, I have rather high hopes that the due diligence movement, referring to the adoption of binding legislation at the domestic and regional level, and perhaps also at the global level through the Business and Human Rights Treaty, will ultimately strengthen corporate responsibility and accountability, creating a new business as usual. Of course, much will depend, as also flagged by Professor Simons, on the willingness of states to enforce due diligence and to connect it to effective liability regimes. Thank you very much for your attention.
Hi, my video is not active, but thank you very much, Daniela, for a really wonderful talk. Really very interesting, and we're going to have questions at the end after we have Yelena's talk, and so we'll sort of do that all together. But for those of you watching, please do consider your questions and put them in the chat, and we'll pose them. But thank you very much, and I'll then turn to our second speaker, who is Dr. Jelena Aparach. Jelena is a consultant and lecturer in the areas of international humanitarian law and public international law. She is currently a member. Sorry, there's my video. I lost control of it there for a moment. Sorry. Jelena is currently a member of the UN Working Group on the Use of Mercenaries. She's written extensively about the role of businesses in armed conflicts and the lack of accountability. And she'll be talking to us today about just that, business and human rights in armed conflicts and selected aspects of that. So, Jelena, if you're there, I'll turn it over to you.
Thank you, Caleb.
There you are.
There I am. Thank you, Caleb, and thank you, Ricardo, and organizers for convening this conference. I think it's an extremely important topic, and it's even more important given the competition that's going to be increasing with the natural resources and access to land and water, not just other resources, but also access to water. I think it's very important to say that also in the context of the climate change. So thank you for the invitation. I also have to excuse myself because I will have to leave after the panel because it has been quite a bit of a rescheduling with the current process going on, negotiating of the PMC treaty. And I would also like to precise that everything I say today will be in my own personal name and not in the name of UN, and will not reflect in any way the UN Working Group on the Use of Mercenaries or the UN in general. I'll start very briefly with some key findings that have been said already by Madame Daniela de Jong, but I think it's important to put it in the context when we talk about business and human rights in armed conflict. So, for example, one thing that we can say is that more the country is rich in natural resources, more likely is going to face the non-international armed conflict. And that conflict will be, as I said, non-international, so mostly civil wars, and very long-lasting civil wars. And we've seen this with the current civil wars that have also been going for 20, 30 years, especially in the global south. Another aspect that's relation to natural resources is also the link between the natural resources and the different categories of actors. For example, small natural resources such as gold, diamonds, precious stones are more likely to be exploited by non-state actors, armed groups, private military and security companies, and I'll come to that later, for financing their military operations. Those kind of extractions do not need sophisticated technology. They don't need knowledge, expertise. So it's much easier for non-state armed groups to exploit them. On the other hand, natural resources such as oil and gas, petrol, would require sophisticated technology, long-term investment, knowledge, expertise, and very often they profit to the big multinational corporations that we often refer to multinational extractive corporations, and carbon majors, if you talk about climate change and others. And so we can see that the two actors can exploit differently natural resources, which immediately also raises the issues, how do we document those and how do we address this? That also raises the issue of legal versus illegal. We often we talk about illegal pillage, referring to pillage by armed groups of gold and diamond and precious stones, so the small natural resources. But we rarely talk about legal pillage, which would have all the connotation and perhaps look from the outside that it is legal, but in reality might not necessarily have all the legal aspects to it. For example, there is lack of transparency between in the memorandum of understanding between multinational companies and some governments. There can be issue of corruption when signing the memorandum of understanding. There can be expulsion of indigenous people or communities from their land. All that will have the appearance of legal, but might not necessarily be legal. Also, as it has been asked, the question, and I think it's an extremely important issue, is the consent of the people where multinational companies is trying to access through legal memorandum of understandings. So legal versus illegal is also very important and not sufficiently addressed when we talk about corporate responsibility. And there is a presumption that there is only illegal pillage that's problematic. I think there is also legal access to natural resources that can very, very often be problematic. And to give an example, the working group on the use of mercenaries has addressed this issue in the report that we presented in 2019 to the Human Rights Council, and I can share the link to the report. It's the report on the relationship between extractive industries and private military and security companies, PMCs, and how these two big categories of multinational companies can very often have so much power in accessing to the extractive sites, and where the governments are actually weak, and there can be a multitude of legal relationship between three actors, extractives, PMCs, and the governments. All of them would be legal, all of them would be obscure, not transparent, and it would be at the end very difficult to pinpoint who would be exactly the responsible person for human rights abuses, which very often leads to lack of accountability. And then also one important aspect on some preliminary key findings is the asymmetric role of corporations in international law. For example, corporations can claim their human rights before European Court of Human Rights. As an abstract entity, they can claim their human rights, and at the same time, human beings cannot claim their rights against corporations before the very same court, European Court of Human Rights. On the other hand, companies can sue states at the international economic tribunals, but the same states cannot go against those very companies at the same tribunal because of the whole conception of international law and the conception of legal personality of corporations. Now, when we talk about corporations in international law, we talk about also what are their obligations under international law. And the issue of corporations being subjects of international law is a very sensitive topic. So very often we say, well, there is a corporate social responsibility. There are lots of soft law initiatives, including binding principles, but not only Kimberley process, as we've seen, the many others, Montreal document from PMC, code of conducts. Very often, apart from very few of them, they do not mention the armed conflicts. So they talk about generally due diligence or some responsibilities of companies at the international level, if those companies are willing to adhere to those soft law initiatives, but very rarely they address the issue of armed conflict. And one other aspect in relation to soft law initiatives is also the issue of due diligence. Violation of due diligence does not give rise to accountability, and it does not give rise to accountability for human rights obligations. To give you a concrete example, the French law on due diligence, where due diligence is compulsory, would provide civil liability, not criminal liability for corporations, only for lack of putting in place the specific guidelines and processes to take due diligence action. That means if the company would say, well, we took all the necessary actions, all the due diligence, whether they violated human rights law or not, this will be enough to avoid accountability. And that's very concerning. And of course, it's not the same thing to pursue company for violation of due diligence obligation or for torture. Now, when we talk about business and human rights in armed conflict specifically, there is the issue of human rights obligations that apply in the context of peace and conflict time. But specifically in the context of armed conflict, there is international humanitarian law that applies to the parties to the conflict, to everybody in the context on the territory of the country where the armed conflict is taking place. And of course, there is still a lot of debate whether human rights law applies directly to companies, and that doctrine is slowly moving forward to consider that human rights could potentially apply to companies directly. But IHL obligations are applicable to different non-state actors, and therefore they could be also applicable to corporate actors. If the corporate actors would have IHL obligations, then they could also be prosecuted for the violations of those obligations. And there have been numerous cases, but those have been recognized, including at the time of the Nuremberg trials, where courts did not have the jurisdiction over companies, but they have nevertheless recognized that companies have IHL obligations. And so if there is a possibility to violate IHL obligations for corporations, then of course we can consider that corporate actors can commit international crimes. Now, the lack of jurisdiction or prosecute those crimes does not exclude or eliminate the possibility that those crimes did take place and they could be attributable to the corporate actors. Now, when we come to the issue of documentation, it's an extremely weak point. We talk about lots of accountability of corporations, responsibility, liability of corporations, but at the same time, when we look about the process of accountability or liability, there are two important phases to consider. One is the documentation or searching for evidence, investigation, collecting evidence to build the files for that corporate responsibility. And then the second phase, prosecution or cases in civil or criminal law at the domestic level. Currently, today, there is almost no documentation at the international level of corporate actors for a very simple reason. International law is a state-centric system, and therefore the traditional doctrine of international law supposes that only states have direct obligation under international law. And as I just mentioned, there is a bit of a change or potentially shift in the doctrine position regarding human rights law, but that's still not definite and it's still not well established. And then, of course, there is the issue of international humanitarian law. The UN-based fact-finding commissions and investigative bodies are mandated mostly to investigate state obligations and if state has violated international law because of this concept of states are subjects of international law and the state-centric approach to international law. There is a bit of a change, and there is a new trend to consider in some cases that non-armed groups, non-state armed groups can be also investigated by some commissions if there is a reference to international humanitarian law to the mandate of those fact-finding missions. But that is also the interpretation made by the commissioners of each specific international fact-finding body. Only 2 fact-finding UN-based commissions to this day have considered the role of corporations. One is the International Fact-Finding Mission on Myanmar that issued a report in 2019 on the specific role of corporate actors in Myanmar and financing the state military. And the second one was just presented during the Human Rights Council in September 2021 on the corporate actors in relation to corruption in South Sudan. So can we consider this as a new trend? It's early to say, but it is a very important message to say, well, actually, when we talk about the armed conflict and the actors and the financing of armed conflict, it's important to look all of the actors to better understand the conflict. And as my colleague just mentioned as well, also to understand how we're going to manage the peace process and reconciliation, and to go beyond just parties confronted in the conflict, but to see that all the other actors and manage the bigger picture of the conflict. So if the companies are at the root causes of conflict, it only makes sense to see their role through the peace building process and to peace agreements. And that still is not really the case today. And there is still not, it's a missing link between looking into the corporate actors, their role in armed conflicts, in crimes that are taking place in armed conflicts, and how this could be and should be addressed through the peace agreements and through peace building process, including truth and reconciliation commissions, but not only. Now, if we pass over the obstacles and challenges regarding corporate obligations and documentations, what could be potentially access to justice and to remedy? Now, currently, we have International Criminal Court that has jurisdiction over civil and military superior persons. So they could basically investigate and prosecute corporate directors. Right now, there is nothing in the Rome Statute that could oppose to prosecuting, investigating corporate actors. So it's the question of prosecutorial strategy. As part of the special procedures, the UN Working Group on the Use of Mercenaries, and with our other colleagues, Working Group on Business and Human Rights mostly, but also some other experts, we have been working towards addressing some of the issues related to corporate responsibility, in particularly within our mandate in the context of armed conflict. So, for example, in June 2020, we have sent the allegation letters, that's called communication system in the special procedures, to different parties to the conflict in Libya to address the role of mercenaries, mercenary-related actors, but also private military and security companies. Last year, in March, we have addressed allegation letters and communications in the context of Central African Republic to the governments of Central African Republic, to the Russian Federation, but also to the company that's based in Central African Republic, Loba Invest, where we have identified that some actors such as Wagner Group, Loba Invest, and Seva Security, companies that were registered in Central African Republic, were involved altogether in a very complex relationships in human rights and humanitarian violations in Central African Republic. I think at this stage today, special procedure mechanism with the system of communications are the only system at the international level that we can concretely address the issues of human rights and humanitarian law abuses by companies directly communicating with those companies and also the relevant states that could potentially be responsible. And it's a very good example of how we can address corporate responsibility at the international level. And currently, the only one at the international level. And of course, when we talk about corporate responsibility, there is also, I think it's very important to mention, the Article 46C of the Protocol on Amendment to the Protocol of Statute of the African Court of Justice and Human Rights from 2014, that has a very explicit and very thoroughly developed provision on corporate criminal liability. But of course, that instrument is still not inapplicable. Some of the biggest challenges, and I will conclude with this today, are the fragmentation of the corporate responsibility doctrine. This fragmentation is specifically in relation to the soft law initiatives, where we have soft law initiatives per sector. For example, for diamonds, we have Kimberley Process. For private military and security companies, we have Montreux Document, Code of Conduct. And so each document addresses in different ways corporate responsibilities, due diligence, and many other aspects. There is no harmonization between those documents, and companies can go and pick and choose whichever that it can suit them. This fragmentation is also reflected at the two processes taking place currently. It's the intergovernmental process for the Business and Human Rights Treaty that is quite well known, and it was mentioned by the first speaker, but also the one that we are discussing this week on the Intergovernmental Working Group on Private Military and Security Companies, chaired by South Africa, that just issued its first draft zero document for potentially international, well, we don't know what's going to be the nature of the instrument yet, but international instrument for private military and security companies. And we see again that there is a fragmentation of the process, which addresses on one side, one specific sector, so private military and security companies, and on the other side, all businesses more general. And another problem, another challenge that we are seeing today, and I think some other speakers will address that issue, is the issue of ecocide and climate change that is very closely related to the issue of access to land, natural resource governance, and access to resources and water, as I said. And it's the problem of ecocide. We have the proposal for the ecocide definition, which can be critical or not in many aspects. I think it's important that we have this ecocide proposal, but again, it's excluding the corporate actors from the proposed definition, and we will have to see how we are addressing this. Just to conclude, there have been also other avenues that have been non-part of the state legal system, but have been very important for victims, communities around the world. And those are the tribunal of opinions, or people's tribunals, as we call them, that have been traditionally addressing since the first Russell Tribunal in Vietnam, the issues that traditional state-based tribunals, whether domestic level or international level, cannot or will not address. And so in that sense, you can find lots of tribunals on the mother's rights of the nature, corporate responsibility in Southern Africa, corporate responsibility in Israel-Gaza context, or in Latin America, access to natural resources. And to announce, there will be the next one on the World People's Tribunal on climate change, and I can answer maybe that later. And I'll conclude here with this. Thank you very much.
Great, thank you so much, Jelena. That was really excellent. I think it filled in the gap of what Daniela started with, and I think that it really. I don't want to say the two parts, but I think it gave a really good sort of range and a spectrum of the issues that we're facing. And I think that you really touched on it very well at the end, talking about, and I think this came through in both of the talks, this notion of fragmentation and how that there isn't any sort of unified approach to dealing with these problems, and so we have to draw from lots of different sources, which I think can be a strength because it means that we have a lot of tools available to us to try to address these issues, but then a weakness to the extent that obviously we then lose a certain amount of of the strength and the of the consistency is the word I'm searching for. So thank you both so much.
Perfect. So good afternoon, everyone. We start in time. My name is Ivan Alogna, and I'm the Arthur Watts Research Fellow in Environmental Climate Change Law at BICL, the British Institute of International Comparative Law. It is an absolute pleasure to be today with you and to be chairing this panel, which promises to be really exciting. We are going to talk about extraterritoriality, transnational legal remedies, and access to justice for Global South victims, and much more. So many thanks to Dr. Ricardo Pereira for the invite, and to the organizing committee at Cardiff University and the European Center for Constitutional and Human Rights for the excellent program they have prepared for us.
Thank you. I hope everybody can see that okay. So I have slightly amended my title, but it's on the same set of case law originally conceived. Transnational corporate liability in the UK for human rights impacts. And I will be looking at key developments following two very positive decisions in the UK courts. Vedanta and Resources and Lungoa, which was decided by the Supreme Court in 2019, and Okpabi and Royal Dutch Shell, which was the Supreme Court decision was decided in 2021. These cases are considered watershed moments in transnational litigation in the UK, and I'm investigating what they add to the transnational corporate liability context and whether these decisions will hold true post-Brexit. So you're probably aware of the factual background of both cases. In Vedanta and Lungoa, it concerned alleged toxic emissions from a mine in Zambia. An action was brought by a group of nearly 2,000 Zambian citizens whose health and farming activities were damaged by toxic discharges from the mine. And an action was brought in UK courts against the subsidiary company, Konkola Copper Mines, a Zambian company, and Vedanta, the parent company, incorporated and domiciled in the UK. And what was at issue was whether the UK was willing to exercise jurisdiction over the tort claims against both parent and subsidiary. And the court decided in favour of the Zambian citizens. The case was set to go to trial, but Vedanta settled without admitting liability, but providing an undisclosed amount of compensation. The facts of Akpabi are similar insofar as there was an action brought against the parent company and subsidiary. In this case, we have the pipeline operator Shell Petroleum Development Company of Nigeria, often abbreviated to SPDC, which is a Nigerian company, and then the UK domiciled parent company, Royal Dutch Shell. This was brought by over 40,000 individuals from the Agole Kingdom and Bile Kingdom in the River State in Nigeria. And they claimed numerous oil spills had occurred from oil pipelines in the vicinity of their communities, causing widespread environmental damage. So they couldn't safely drink water, couldn't fish or engage in agriculture. The case was decided in favour of the claimants, so the court found that they could exercise jurisdiction over the parent and subsidiary. So this is obviously quite positive judgments insofar as jurisdiction was pronounced over parent and subsidiary. Former transnational litigation prior to the Brussels regulations included just a lot of actions against the parent company using the forum non-convenience doctrine, and I'm going to explore this further. Longoa and Akpabi are pre-Brexit cases. The Supreme Court decision of Akpabi was decided after Brexit, though. There is a concern arising that EU law featured significantly in determining jurisdiction over the anchor defendant, the English domiciled parent company. Establishing jurisdiction over the parent company is the first step in establishing jurisdiction over whether the foreign defendant and the subsidiary company will be found. So EU law featured quite significantly in providing for jurisdiction over both parent and subsidiary. So what will happen without EU law? And I'm going to go into this in greater detail. Whether or not English courts could exercise jurisdiction over a parent for wrongs committed in a foreign state was regulated by Article 4 of the recast Brussels regulations, which stipulate that persons domiciled in a member state shall, whatever their nationality, be sued in the courts of that member state. And whether or not they'll be sued in the member state court is usually up to the claimants. And the Court of Justice of the European Union, Owusu and Jackson, confirmed that the principle of foreign non-convenience could not be used as a bar against a parent company for actions committed in a foreign state. So EU law precluded application of the foreign non-convenience rule in deciding whether foreign claimants could bring an action against an English domiciled company. The main focus then concerned whether jurisdiction could be exercised over the foreign subsidiary, because that first hurdle was fairly simple. What happens without EU law, without the Brussels regulations? So we see that in terms of an explanation of foreign non-convenience, I'm sure we're all aware of what it is. It's a discretionary power of the court to decline jurisdiction to hear a case when another court is better suited to hear it. It is a common law doctrine which allows a court to dismiss a civil action where an appropriate or more convenient alternative forum exists. And there are different factors that are taken into account when deciding which forum is appropriate: where the harm took place, where the claimant is from, whether hearing it in an English court runs parallel to other proceedings, thus resulting in duplication or inconsistency of outcome. And we talk about the Spiliada doctrine, which is the Spiliada Maritime and Consulates case, is how the courts approach forum non-convenience. They engage in those questions of what the natural forum for resolving the dispute would be. And then there is an exception to application of the forum non-convenience. So even if they find that the natural forum would be the host state forum, the claimant would be denied substantial justice if it were to be litigated in the foreign forum, and therefore they decide that they will exercise jurisdiction over the case. And in terms of how this is played out in English courts, in Lubin Cape and Connolly and Ortiz Z, which involved significant human rights impacts in different states, they said that they used the denial of substantial justice exception. So they found that the natural forum was the foreign state as a result of all of the wrongs being committed there and the claimants being located there. But then they found that there'd be a substantial injustice if the English courts couldn't adjudicate upon it, because the claimants would be effectively denied justice as a result of possibly lack of resources, lack of expertise in litigating the area, perhaps corruption within the governmental and court system in the host state. So we see that forum non-convenience prior to the Brussels regulations was quite were found often in favour of the claimants as a result of this substantial injustice clause. So Brussels replaced the foreign non-convenience principle, and it couldn't be used. The parent company, they wouldn't have to go through the Spiliada analysis. They would just say the parent company can be sued in the home state courts. So the next issue, the next step in these proceedings against the parent and subsidiary is determining whether the foreign subsidiary can be sued in the UK court. And this is regulated by the civil procedure rules, which are enshrined in Part 6, Practice Direction B. And it states that the claimant can serve a claim out of jurisdiction with the permission of the court, where a claim is made against a person, the defendant, on whom the claim form has been or will be served. And there is between the claimant and the defendant a real issue which it is reasonable for the court to try, and the claimant wishes to serve the claim form on another person who is a necessary or proper party to that claim. So this means that in order to exercise jurisdiction over a foreign subsidiary, the claimants have to prove that there is a real case to be tried against the parent, that they're not trying to hook the proceedings against the subsidiary sort of falsely upon the parent, and that there is a real issue to be tried and they're a necessary or proper party to the claim. So this is the next analysis that needs to be undertaken. And in terms of the forum non-convenience, it does make an appearance in, even with the Brussels regulations in place in relation to the foreign subsidiary test. And it makes an appearance whenever they're considering whether it is a reasonable case for the court to try. And Katarina Aristova provides an excellent analysis of the case law in this respect. She stipulates that the rationale and principles applied in this analysis in Lungoa are the same as those that you would use under the forum non-convenience in Spiliada. So forum non-convenience is still a part of the UK approach. So, for example, in the High Court and Court of Appeal, they said that an arguable claim against the foreign subsidiary was made under the first limb of Spiliada. It was necessary to hear the case against the foreign subsidiary in the UK, because it was necessary to avoid parallel proceedings on similar facts in two jurisdictions that could arise if they would only hear the parent in the UK and not the subsidiary. So they didn't want conflicting judgments on the same issue. In terms of the Supreme Court, it was found that Vedanta would have agreed for the whole case to be heard in the host state in Zambia. And Lord Briggs concluded that the first limb of the Spiliada test would not be met. So he was saying that Vedanta, agreed that the whole case could be heard in its entirety in the host state, and therefore this necessity to hear the case against a subsidiary in the UK couldn't stand, because they were willing to hear all of it in Zambia. But Lord Briggs then invoked the second limb of Spiliada and said there would be a substantial injustice if it was not heard in English courts because of the lack of resources in Zambia to hear the claims. So we see foreign non-convenience still forms a part of the approach when EU law is applicable when it comes to the foreign subsidiary, and that it didn't prevent an injustice here. So we know that the UK tried to sign up to the Lugano Convention, which is a convention extending the private international law rules and EU law to non-EU states, including Iceland, Switzerland, and Norway. And in order for the UK to join, they needed the consent of all the parties to the Lugano Convention and also the EU. The parties did consent to the EU accession to the Lugano Convention, but the EU didn't, which means that the UK cannot avail of EU private international law rules. So it has to fall back on its own common law principles. And there are those who are concerned that the fact that we have to do the foreign non-convenience test in relation to the parent will make it more difficult for claimants to make this case. But one argument that could be made is that foreign non-convenience has still formed a part of the pre-Brexit position, and the courts have claimed jurisdiction over the case in any case, and also in the pre-Brussels regime in Lubin Cape and Connolly case, you can see that the courts find it favourably in terms of the claimants using the second limb of Spiliada. So the extent to which leaving the EU does damage the prospects of claimants are not as extravagant as people may think, is what I believe, but I'm interested in hearing other people's opinions on that. A second aspect that I wanted to address was the duty of care test set out in these two cases. So, what are the positives and shortcomings of the duty of care test set out in Lungoa and Fabi? So in the duty of care test set forth in the context of trying to decide whether there was a real case to be tried against the parent in order to find jurisdiction over the subsidiary. And they needed to make a preliminary ruling on whether a prima facie duty of care existed between the parent and the victims in the foreign state in order to ensure that a real case was to be tried against the parent. So there were guidelines set out, and these guidelines have been celebrated quite significantly. They show that a parent can incur a duty of care in a number of circumstances, including when they lay out group-wide guidelines for all its subsidiaries, and they hold itself out as exercising control over the policy and guidelines that have led to the human rights impact. Now, they have limited it in certain regards, so that liability can only be found whenever the particular measures are taken in relation to one subsidiary and not the whole group of subsidiaries. So that's a significant limitation on the duty of care test put forward in Vedanta Resources. So in Okpabi and Royal Dutch Shell, they engaged in a much less rigorous of whether a duty of care existed, because they felt that it was just still the preliminary proceedings. They shouldn't be engaging in a detailed analysis of whether a duty of care exists. They said that there was a very high burden of proof on Shell to prove that they didn't need to disclose further evidence in support of this case, so that there was no further evidence suggesting that they had contributed to the harm. So it was very much so based on disclosure and whether there was a point to further disclosure. But they did reiterate the Vedanta test in terms of duty care, when it holds itself out as exercising that degree of supervision over its subsidiaries, even if it doesn't in fact do so. So it does reiterate Vedanta, but it's much less willing to engage in an analysis of duty of care. So, and that's just 3 things to bear in mind. There's a duty of care between the parent and victims of subsidiary harm. The corporate veil remains intact because they're not holding the parent responsible for what the subsidiary does. They're holding them responsible for the omissions of the apparent. So corporate veil remains intact is one reading of it. But again, I'm interested in hearing people's opinions. And this is just a jurisdiction case. So it's not on the merits. And we don't know how significant the duty of care test will be for the merits. So in terms of outcomes, as I say, it's just a jurisdiction test and we have yet to see whether it will be used in the merits. However, it is good to see that the Dutch Court of Appeal in the Milieu Defensie and Shell case used the Lungoa test to establish a duty of care between a parent company and foreign victims on the merits. And this is a very significant case. It's the first European case to find a duty of care a violation of the duty of care between the parent and the victims in Europe. And it was the Lungoa test that it did employ. It has been criticised for being a misinterpretation of the Lungoa test because they underwent an analysis of whether the subsidiary had breached a duty of care. And it was only if the subsidiary breached a duty of care that the parent would be found responsible for the breach of the duty of care of the subsidiary, which wasn't necessary in the Vedanta case, where the corporate veil remained intact. In the UK case, the Dutch case, they broke the corporate veil essentially. But we can see this cross-fertilisation is quite hopeful, and it's having an impact abroad. One of the negatives is that it arguably discourages parent companies from exercising due diligence or holding itself out as such, because it is only when it exercises due diligence in relation or holds itself out as such in relation to one subsidiary that it will be held liable because of the nature of tort and the proximity criteria. And fair, just and reasonable, not imposing too much of liability on the multinational corporation. So if all the subsidiaries are engaging in gross human rights violations under the test, it's less likely that they'll be held liable. So the other thing that I wanted to mention is that culturally, I think Vedanta and Ukpabi, or Ukpabi and Lungoa, represents a sea change in the approach of the UK courts. We see 2 cases in the pipeline, the Josiah and British American Tobacco case and the Hamida Begum and Marin case. Both cases concern the court refusing to strike out claims in relation to foreign groups of claimants who had human rights impacts committed against them, but they're related to supply chain cases. They're not related to subsidiaries. So in one, it's related to the work conditions on a tobacco farm against the British American Tobacco Group. And in the other case, it's about a UK company selling a ship to be demolished in Bangladesh, and the Bangladeshi company that demolishes the ship imposing terrible work conditions and someone dying on site. So it seems like Lungoa, there is a sea change, a cultural shift in UK domestic litigation, even if we think of these particular cases as quite limited in their scope as jurisdictional cases. So that's all I wanted to say today. I've really enjoyed the paper so far, and thank you for having me.
So my talk is going to be about holding corporations to account the chimera of customary international law, basically looking from a litigator's perspective with litigation against transnational corporations in connection with violations of human rights, as to whether there is an action separate from a tort action based on the fact that the corporation has committed a violation of customary international law, which has then caused harm to other people. So it's looking at whether there is this possibility of some horizontal effect of certain norms of customary international law, which will be relevant in civil cases brought by one private party against another. And the chimera in Greek mythology is a fire-breathing female monster with a lion's head, a goat's body, and a serpent's tail. There it is. The second definition is what is really I have in mind for the title of my talk, is a thing which is hopeful but is illusory or impossible to achieve. Is that something which we can say about the possibility of bringing actions against transnational corporations which are based on the fact that they have violated norms of customary international law? Now, I think this all starts, this possibility of such an action starts in the United States when in Philatica in 1980, the long dormant alien tort statute has been rediscovered. And just to refresh our minds on that, the district court shall have original jurisdiction over any civil action by an alien for a tort only, and here are the key words, committed in violation of the law of nations. And it's those words which have led to an extensive development of civil claims in the US district courts against transnational corporations, particularly from about 1997 onwards, in the Doe and Unicol case arising out of participation of an American corporation in a oil extraction partnership in Myanmar, and whether it is aided and abetted forced labor imposed by the Myanmar military. Unfortunately, this development looks as if it's coming to an end. The Alien Tort Statute has been severely restricted in the last 10 years by 3 Supreme Court decisions. Kiobel and Royal Dutch Shell in 2013. There's a presumption that domestic statutes have no extraterritorial application. And even where the claims touch and concern the territory of the US, they must do so with sufficient force to displace that presumption. So that's quite a substantial limitation. 2018, Jesner and Arab Bank, the Alien Tort Statute doesn't give jurisdiction over claims against foreign corporations. And then in the summer of last year, in July 2021, in the case of Doe and Cargill against Nestle, there's claims which have been brought against US corporations, and the allegation is that they have allegedly aided and abetted child slave labor in cocoa farms in Mali. But the Supreme Court says, well, nearly all the alleged aiding and abetting conduct occurred outside the US, so this case is not appropriate for the Alien Tort Statute, and allegations of general corporate activity like decision-making in themselves can't establish domestic application of the statute. So it's very much on the way out, I think, claims in the US based on customary international law against corporations. I think the Alien Tort Statute is pretty well being closed down as a result of that final Supreme Court decision. But as one avenue for the development of civil liability in an action based on a company violating norms of customary international law, as one door seems to shut, shortly before that, another door seems to open. And that is the position in Canada. It's the case of Nevson and Araya, and that involves allegations of forced labor by free workers at the Bisha gold mine, which is in Eritrea. There is a system whereby after you've done your term of conscription, if you're very lucky, you can then be forced to carry on working for the military who are running this gold mine, and you are going to be forced labor. Well, these free workers managed to get away from Eritrea and have brought a claim in the courts in Canada. The Bisha Mining Share Company, which ran this mine, was partly owned through a 60% share by a Bermudan subsidiary of a Canadian mining company called Nevsun. And the free workers brought tort claims against the parent company, Nevsun, and they also brought claims based on violations of customary international law, aiding and abetting claims, aiding and abetting the use of forced labor and slavery, torture, cruel and inhuman or degrading treatment, and crimes against humanity. Those are the four new tort claims which were made in parallel with ordinary tort claims. And on the 28th of February 2020, the Supreme Court of Canada decided by a narrow majority that they were not going to strike out these claims. That doesn't necessarily mean that they accepted that the claims would be possible to be brought on the basis of a violation of customary international law, but it was plausible that they could be so brought. And by a much larger majority, they decided that they would not strike out the claims on grounds of act of state. I'm not going to say anything more about that because I'm aware time is short. And I want it really just to focus on this possibility of an action based not on conventional tort, but on the fact that the person you are suing has violated a norm of customary international law, and that caused you, the claimant, harm. Now, the majority in Nevsun based their decision in the strikeout proceedings on a previous case called R versus Hape, and they decided that the way customary international law comes into domestic law is that Canada automatically incorporates it via the doctrine of adoption. There's no need for any legislative action, and it then becomes part of the common law. The compelling argument that as customary international law is part of Canadian common law, then a breach by a Canadian company could theoretically be directly remedied in civil claims against it. And finally, these are very much summaries of the key findings of the majority. It's a much more complicated decision, which I don't have time to go through all the intricacies of it. But international human rights norms were routinely applied to private actors. And it was not plain and obvious that corporate actors were excluded from direct liability for violating obligatory, definable, and universal norms of international law. And I think direct liability for violating obligatory, definable, and universal norms of international law actually links back to what had been going on in the alien tort statute cases against corporations, that the civil liability is based on that a corporate actor has violated obligatory, definable, and universal norms of international law. Now, there was some controversy, and I will come back to that as I develop my discussion, on whether there was any applicability of norms of customary international law to corporate actors. And that's something which in particular the minority judges said has not been established as a matter of international law. And indeed, it is something which is subject to quite a deal of difference between the different circuits who were hearing these ATS cases in the United States. And then there's an important observation by the majority that the public nature and importance of violating these particular types of norms and the rights which are being violated underneath these universal obligatory norms which affect individual actors, it requires a different and stronger response than just your ordinary common law garden tort claim. And then they concluded that for the purposes of the strikeout application, it was enough to conclude that breaches of customary international law or US cogens relied on by the Eritrean workers might well apply to Nevson. That's enough to avoid the claims being struck out at this stage. It doesn't necessarily mean that it is definite that there would be a civil action based on a violation of customary international law. That would be something for the trial judge to decide. But there was no trial judge. The case settled in October 2020. And what I want to do now is to explore some of the possibilities which would emerge if we are looking at a viable civil action based on the fact that the defendant has violated obligatory norms of customary international law. And again, it looks rather strange. You think international law is something which governs the conduct as between states. How does it apply to individuals? Well, we'll find out in a moment. What I want to look at is what would this action look like, and would it actually be useful in proceeding against multinational corporations in respect of their complicity in violations of human rights? Well, I've identified 5 problems. First of all, what are these norms of customary international law that can be violated by natural or legal persons? And I think the answer comes from international criminal law and also possibly we might then say jus cogens norms of customary international law, and also crimes of universal jurisdiction. That seems to be the core subset of obligatory norms of international law, which are capable of affecting private people. And that really comes through from international criminal law, which was established with the tribunals at Nuremberg and in Tokyo at the end of the Second World War, and has continued with various international tribunals, former Yugoslavia, Rwanda, and also we have the development of the International Criminal Court through the Rome Statute of 1998. So, putting it very simply, conduct which would be criminally an international crime can form the basis of civil liability brought in a claim by a private party who has been affected and damaged as a result of that internationally criminal conduct. And it's not just primary participation, the primary participation in the established international crimes. And basically there are three of them, which are war crimes, crimes against humanity, and genocide. But if we expand the net to crimes of universal jurisdiction, we end up with things like piracy, but also things like slavery and forced labor. Most of the Alien Tort Statute claims which were brought on this basis were brought on the basis of secondary participation, aiding and abetting those crimes. The second question is corporate liability. Now, do these norms of international law, which can affect private persons, do they also affect corporations? And one of the arguments which has been raised is that no, they don't, because they derive from international criminal law, and all the international criminal tribunals which we have seen, and also the Rome Statute, only give jurisdiction over criminal jurisdiction over natural persons. And there's been a circuit split in the US on this issue. Although in the Doe and Nestle case, there was a non-binding finding by the majority, 5-4, that corporate liability would be possible under the ATS. So that's an issue which would have to be decided. For my part, I think that the norm clearly applies to all private parties, and the fact that there are not institutional mechanisms so far for bringing international criminal proceedings against corporations doesn't affect the fact that there is a binding norm which affects all persons, whether they are natural persons or legal persons. But again, that's something which would have to be decided. Then we get on to the question of aiding and abetting. And I think we had some discussion about this in the questions on the previous panel, particularly with discussion about the proceedings against Chiquita. As a matter of international tribunal law, the prosecutor in Forensiga is a case before the tribunal for the former Yugoslavia, and that stated that the actus reus of aiding and abetting is practical assistance, encouragement, or moral support which has a substantial effect on the perpetration of the crime. And I think that substantial effect is something which is worth pondering, because it may be that many of these cases which involve corporate complicity in international crimes by other actors, state actors, for example, security forces, the people running the Eritrean military who are running the Bisha mine and are responsible for the forced labor imposed on the former military conscripts. It leads to the question of the company which is involved in this project. Has it given practical assistance which has a substantial effect on the perpetration of that particular crime? And when you look at the Nevson case, where Nevson has got its subsidiary, which has got a 60% holding in this Bisha mine venture, is that 60% holding, is the financial support for the project, is that something which actually gives substantial assistance to the crime which is committed by the Eritrean state company, which is actually operating the mine and is committing the 4 alleged crimes pleaded by the Free Eritrean Workers. And in a case called South African apartheid litigation, which was in the New York circuit, it's an alien statute case, and I think judgment was given in 2009. Claims were made against various banks for aiding and abetting violations of international law in connection with providing loans and purchase of South African Defence Forces bonds. So you're providing money to the South African apartheid state. Is this aiding and abetting the violations of international law which the South African apartheid state is committing? And Justice Sheindlin was of the view that it didn't amount to sufficient assistance. To supply a violator of the law of nations with funds, even funds that could not have been obtained but for those loans, was not sufficiently connected to the primary violation. And that's something which, if the Nevson case came to trial, might be a sticking point in finding liability on the part of Nevson through its subsidiary. The fourth problem is the mental element of aiding and abetting. And essentially, the problem is, are we talking about knowing assistance, that you give the substantial assistance, knowing that that is going to assist the primary violator in committing violations of international law? Or do you have to give the assistance sharing the purpose of that violator? So it's either knowing assistance or purposes of assistance. And we've got a split between most of the decisions of the international criminal tribunals, which go for knowing assistance, but also the Rome Statute, which established the International Criminal Court, seems to go for purposive assistance. And that's particularly true for Article 25/3 of the statute. A person shall be criminally responsible and liable for punishment of a crime if that person, for the purpose of facilitating the commission of such a crime, aids, abets, or otherwise assists in its commission or its attempted commission, including providing the means for its commission. And again, in the United States, in the ATS cases, there's been a circuit split as to what is the mens rea for aiding and abetting in connection with liability for civil liability for participation in an international crime. And if we look at Nevson's factum, so what Nevson was saying, I suppose a factum is basically a skeleton argument. It commented on the problems in operating a cause of action based on customary international law, and it identified one problem: whether to apply the common law joint or concerted action test, which would be the test for showing that the party you're suing is jointly liable with the party who has actually committed the acts which have harmed the claimant, that there is a concerted action between these two defendants? Or are we going to have the international criminal law standard of complicity and aiding and abetting liability? The latter are relied on by the plaintiffs here. And I think what Nevson would be thinking about is that there's a difference between knowing that your assistance is going to aid in the violation of human rights by the primary perpetrator, and sharing the purpose so as to make you a joint tortfeasor under the ordinary tort law of joint liability. And then a fifth question: why is Nevson involved? What about parent company liability? Nevson's the parent company. It's one of its subsidiaries that is actually involved in the Bishop mine with a 60% holding. It's a separate legal person. And here, some idea of how the plaintiffs might argue this point had it come to trial. It's in Arias Factum. The respondents assert that Nevson had a duty to prevent the use of forced labour at the mine. Now, the duty comes from the control which Nevson exercises over the construction and operation of the Bishop mine, its knowledge of the risks of forced labour and human rights abuses present in Eritrea, and also its corporate social responsibility policies, which place the responsibility for compliance with labour and human rights standards on the highest levels of the company in Vancouver. And that, again, is something which would have to be established. And I'm not entirely sure that that would be enough successfully to show that the parent company would be liable in respect of effectively the position of its subsidiary. But again, it is essentially alleging some form of direct involvement by the parent company in the construction and operation of the mine and its knowledge of the risks of forced labour and human rights abuses there. It's also the reference to corporate social responsibility policies might be an invitation to parent companies perhaps not to have corporate social responsibility policies if they are going to be used to form the basis of a claim that the parent company has undertaken some direct duty of care to those who are affected by the operation of its subsidiaries' operation, something which I think we heard about it in Jane's talk just before I started. Okay, what about the United Kingdom? Can we have CIL claims in the UK? Well, we actually have had claims brought on the basis of international law prohibitions, two claims in which torture was pleaded as a separate tort from the ordinary tortious claims which would be generated as a result of somebody torturing another person. Trespass to the person comes to mind. Al-Adsani in Kuwait and Jones in Saudi Arabia. Now, both of these claims get struck out because they are claims against the state, and in Jones in Saudi Arabia, it's claims against a state agent, the actual torturer, as well as against the state. And the effect of sovereign immunity being claimed by the foreign state, both for itself and for its agent, meant that these claims could not proceed. Although they involve a jus cogens norm of international law, there is also international law procedural rule about the right of states to claim sovereign immunity for their official acts and the acts of their agents. So I think it still could be possible, because if you're suing a transnational corporation, there's no possibility of sovereign immunity being pleaded, and if you're claiming that it is aiding and abetting a wrong committed by a state body, there's after Belhadj and Straw, there's not going to be the possibility of the action being stayed on grounds of act of state. So I think it is open that CIL claims could be made in the United Kingdom. However, I leave you with a cautionary tale from a recent article by Richard Meeran of Lee Day, Multinational Human Rights Litigation in the UK Retrospective, back in June 2021. So Lee Day are the company who have brought virtually all the extraterritorial claims against transnational corporations since the early 1990s. And this is what he says: the key objective of claims is usually to win their case and obtain redress. Given that these cases are complex and hard fought on any basis, claimants opt for the easiest route to success. Creating unnecessary legal hurdles will significantly reduce the prospects of success, which is not in victims' best interests. Serious environmental cases, for example, are properly recognized as human rights cases. However, pleading them as such would be very risky. So I don't think that we are going to see any claims being made on a CIL basis, a violation of CIL in the UK. And I think these will continue to be made through the law of tort. And one wonders what would be the advantage of claiming under a violation of customary international law. And the one obvious advantage might be the publicity. By claiming that the company has participated in a violation of international law, that is a much more serious charge against it than just the fact that it has committed an ordinary tort. So that's where I shall finish, and I will leave you with another picture of a chimera. Thank you very much for your attendance.
Thanks, Simon. Thank you very much. That was really interesting. I look forward to hearing more about this, but I think that we are really, we don't have much time then left. Thank you very much again. So now let me introduce our next speakers. We have Josh Roberts and Dr. Virginie Ruas. And I don't know if I pronounce correctly. Josh Roberts is a qualified member of the California Bar, currently working as Senior Policy Advisor for RESCOP.eu, an EU industrial association representing energy cooperatives in the field of renewable energy, energy efficiency and flexibility. Since 2012, he has provided legal expertise in Brussels on EU law and energy and climate law, including on the energy market and renewable energy. He has practiced public interest environmental law in London, specializing in a number of areas, including international environmental law, of course, water law and governance, forest governance, human and indigenous people's rights law. Dr. Virginie Ruas is a research associate at SOAS, the School of Oriental and African Studies in London, where she's pursuing research in her field of interest. Her main areas of expertise include access to justice, business human rights, environmental law, and EU law and policy. She is currently developing a monograph based on her doctoral thesis, which explores the interplay between access to justice and business human rights in European civil law countries. She is also an editorial board member of the Journal of Law, Environment and Development, LED. And Virginie also works as a lead advisor for Milieu, which is a multidisciplinary consultancy based in Brussels, providing legal and policy service for the EU institution and other international organizations. So they are proposing us a presentation with a quite captivating title, Another Inconvenient Truth, Business Human Rights Impacts of Europe's Energy Transition. So Josh and Virginie, you have the floor.
Well, thank you for the presentation and thank you for having us today. So I will share my screen so that you can see our PowerPoint presentation. Can you see it?
Yeah, perfect.
All right. All right. Oh. There you go. Thank you very much for having us. I just would like to correct one thing is that I actually did publish my monograph in January 2022, where I explore access to justice in a business and human rights context. And my research focuses on transnational litigation against corporations in European civil law countries. So I just wanted to mention that and do a little bit of self-advertising. Sorry for that. So before I start the presentation, I would like to give a little bit of background information about this presentation and the work Josh and I are doing. So Josh works on the clean energy transition in the EU, while I do work on business and human rights. And so in recent years, Josh and I have had many conversations about our two areas of specialization. So including the environmental and human rights risk associated with the energy transition. So we decided to explore this topic because this is a topic that is important to us. And we really decided to explore how the EU takes into account this risk, especially those that take place in an extraterritorial context. So how the EU takes those risks into account in its policy and legislative instruments and initiatives, and whether the EU's approach is actually sufficient to ensure that the energy transition is not only environmental, but also just and respectful of human rights. And spoiler alert, there are like problems not only with human rights, but as well with environmental protection. So in our presentation, we will mainly present the issues at stake because they are quite complex and they need to be understood in order to analyze the adequacy of European policies and legislation in this field. We will briefly present the instruments that we consider relevant in the field of energy transition and business and human rights. So again, we're really trying to explore the interplay between energy transition and human rights. And those are naturally different fields, but they have connections. And finally, we will briefly assess the recent proposal for EU directive on due diligence and actually how this proposal could address the human rights and environmental risk linked to the clean energy transition in Europe. So I will now hand over to Josh.
Thank you very much, Virginie. Yeah, so just to give you a kind of context for where we enter this this topic. I mean, we've all kind of heard the slogans. You know, we've heard the policy initiatives, the Green New Deal, and all of this. I mean, it seems that our decision makers are finally waking up to the global crisis of the climate and the environment. And you see this in particular, especially with the Repower EU initiative. I think the war in Ukraine has kind of furthered the impetus for action to move away from fossil fuels. And of course, we all support that. And there are some strands that we also support. I mean, we see this as a green ecological transition. So it's about decarbonizing the energy sector, but it's also about addressing some of the inequalities that we see in our economic system with regards to energy, for instance, reducing energy poverty. In my field, I focus on citizen participation and ownership of renewable energy technologies. So allowing people to actually participate in this and get something from it, reducing pollution and waste, of course. If you live in a city, you know that in the summer it gets very polluted and your kids suffer from health, breathing problems, stuff like this. We want to live in a cleaner environment and we want a more sustainable economy. We see the ecological limits that all of our industrial activity is heading towards. And of course, all of this, our reliance on fossil fuels and imported fossil fuels at that, they put us in morally dubious positions with regard to allowing our decision makers to either, fund weapons. I mean, I come from the US, we have wars about oil, we fund the Saudis who, commit genocide in Yemen. These are things we don't like, but we don't have much power to do anything about them. So this is what the transition is about. And particularly in Europe, we want to decarbonize our energy use. and we want to change things from the past. This is not just about consuming clean energy, but it's also creating a new economic system that is more in balance with being able to survive on this planet for the next few hundred years or so. So the next slide, if you will, Virginie. And that kind of introduces us into the Green New Deal. And I mean, just to kind of, a lot of people might ask, what is the Green New Deal? Personally, I just more or less see this as a kind of a chapeau or a narrative that the new commission came in with von der Leyen as a way to organize their policy agenda. And a lot of sort of strands of policy have come from that. Of course, we have the climate ambition, we have greenhouse gas emission reduction targets, renewable energy targets, energy efficiency targets. But we also have these strands around a more circular economy, reducing waste, making sure that it is cleaner in the way that we process it, promoting recycling, moving away from fossil fueled vehicles to more electric vehicles, smart mobility, and a just energy transition. We are moving away from fossil fuels, but here in Europe, since a lot of our economies have been based on that, especially in like Poland, for instance, it's about giving these communities an opportunity to move away from local economies that are based on fossil fuel extraction, for instance. And of course, sustainable finance, making sure financial flows are going in the right way. And this green oath of do no harm, that's kind of a broad moniker, but it's more or less a mechanism that people like you and me can actually tell the EU if their policies are having a negative impact. But then there's also the external dimension, and the EU has elaborated a number of policies on that. And a lot of what we will focus on in the next slides is about trade and sort of the securing of strategic raw materials, this is the inconvenient truth that we are talking about. Next slide, please. So what are we talking about? Well, interestingly enough, if you look at some of the studies that the International Energy Agency or IRENA or anybody who's following this topic is covering, you will see that the amount of raw materials that go into these clean energy technologies are actually even more substantial than for traditional fossil fuel technologies. Of course, for fossil fuel technologies, everything comes from the ground, uranium, coal, oil, gas. But the amount of minerals or materials per amount of energy is actually much higher for these transition technologies. So from electric vehicles or even battery storage in houses, lithium ion, these take up a lot of different types of natural resources. You see here on the right, this kind of goes through all the different technologies that we need, everything from what I consider good, or you might consider good, from solar power or wind, to some of these more, industrial-based technologies like hydrogen. They all require this. And then you see down on the bottom left, this isn't so much with regard to human rights, but this is the supply risk. This basically shows all of the resources that the EU relies on in order to develop these technologies. And you see the color scheme, it goes from very high supply risk. So there are actually a lot of high supply risks. We rely on sourcing these materials from a lot of different countries. Some of them have lower risks, but the ones that are most critical to the energy transition, and I can explain that in a bit, are very at high risk. And of course, in these countries with high risk, they also have some dubious profiles around respect for human rights and commitments to democracy. So we are really sort of challenging ourselves. I mean, we've heard everything from the EU coming that we want to get away from Russian fossil fuel and gas. That's fine, but if we want hydrogen, some of the resources that come from there are also coming from Russia. China has almost a monopolistic control over a lot of the processing of these materials. So we have to take this into account. Next slide, please.
So like Josh said, clean energy technologies will require more minerals and fossil fuel-based counterparts. And so we are in a situation where there is extreme reliance on minerals for clean energy transition. And this reliance creates a number of challenges from a sustainability and ethical perspective. So, I mean, Josh already touched upon this. The first set of issues arises from the availability of minerals for the production of clean energy technologies. So the minerals needed to manufacture clean energy technologies may only be found in certain parts of the world or in countries that are politically unstable or with a history of human rights abuse. So for example, almost 60% of global cobalt production comes from the DRC. Another example is palladium, which is critical for hydrogen energy, and 40% of it is actually coming from Russia. So this context creates a problem in terms of transition minerals supply. How can businesses ensure that they are not sourcing minerals from countries or areas where there is significant corruption or human rights abuses or conflicts? So this aspect is actually exacerbated by the fact that substituting one mineral with another one to manufacture specific renewable energy technologies may be difficult, if not impossible. So a very good example of that is the case of rare earth elements, which are actually necessary for the production of specialized magnets used in electric vehicles, as well as energy storage technologies and wind turbines. So rare earth elements demand and supply are actually both concentrated in China at the moment. In 2017, China accounted for 80% of rare earth production, and it held 36% of global reserves. One aspect about this is that it's actually very difficult to substitute rare earth mineral for other ones to develop the technologies I just mentioned before. So a second aspect to take into account is that mining and the mining industry, they basically have a history of human rights abuse and environmental pollution. Recently, the Business Human Rights Resource Center released its Transition Minerals Tracker 2021. And it basically provided that between 2010 and 2021, there were at least 495 allegations of human rights abuses linked to extraction of transition minerals. So that's a lot. It's probably the tip of the iceberg. So there are probably more of those. It's interesting to note that actually 63% of those allegations concern human rights abuses against local communities and civil society organizations. And 34% of those allegations involve environmental impacts of mining activities. So for example, water pollution, access to water, violation of environmental standards, impacts on wildlife and habitat, absence of environmental impact assessment. So there are like heavy impacts on local communities and the environment.
Yeah, and I mean, so mostly we focused on sourcing, but as we will kind of show a little bit later, we are looking at the sort of whole life cycle of where these minerals come from and where they're sort of processed and how they're actually put into technologies that are deployed. So, I mean, I'm not going to go into any of these cases in any specific detail. It's just to show that there are already cases around citing projects like wind seems to be the most common one. I think hydro, obviously that has a long history, but we're not focusing on that. But solar as well, these, we have large projects. I think the most interesting one that we've seen so far, it actually comes from Morocco. And that is kind of interesting because if we've seen the EU, the idea is to create an internal energy market, but also to expand that market so that we are basically sourcing solar and wind electricity from Africa and exporting it or importing it back into the EU. So, again, where I come from in my background, we focus on giving local communities, agency, and these to decide how they are planned, but and to be able to take ownership. And of course, there are some good practices around this, but of course, we are focusing on the instances where a lot of it has to do with indigenous communities, the lack of following free, prior, and informed consent standards according to international law. And even some of this is happening. I mean, Norway is not in the EU, but it is part of the European continent. And they're, they won a case against this, against a state-owned company for siting wind turbines on their land, which was basically inhibiting their ability to herd their reindeer. And despite a case against them, those turbines are still going on. So, I mean, everything throughout the life cycle is relevant in the scope of our research. And perhaps one of the biggest challenges here is also after the technologies have been used and they've come to the end of their life, and they either need to be either recycled or the waste needs to be dealt with in another way. Interestingly enough, I mean, some of the resources that are used in these technologies are highly recyclable, in particular for wind, lithium-ion batteries, and solar PV. Technically, it's possible to recycle a lot of these materials. And there is legislation that is increasingly focusing on this. The problem is that the market hasn't caught up. So it's often complicated, and it's not cost competitive with sourcing raw materials, again, from the countries that we already talked about. And the amount of waste here, it's probably too small for you to see, but these graphs here on the bottom left-hand, that basically shows the amount of waste coming from different continents at the moment, but also to 2050. And you don't need to be a rocket scientist to see that the bar goes increasingly up over the next 25 years. So this is a really big issue about how we actually use these things and get rid of them.
So we just presented a number of issues that arise in the life cycle of energy transition technologies. So here on this slide, we kind of summarize some of the issues that we mentioned, and especially from a human rights and environmental perspective. And so in general, there are environmental and human rights risks at all stages of the life cycle of clean energy technologies. So whether it is when sourcing raw material, where we may observe the risk of, for example, armed conflict, forced labor, environmental damage, biodiversity loss, or water pollution. It might be, we see some risk as well, whether it is when clean energy technologies are being deployed, where we may observe a lack of consultation and free and informed consent of local communities or displacement. We also observe risk, whether it is related to waste linked to clean energy technologies. I mean, right now, there is a significant issue with waste dumping, especially in developing countries, from waste coming from developed countries going towards developing countries where waste are dumped and create problems for local communities. And so there is, as we are going to use more renewable energy technologies, there is a risk that there is a clear risk with waste management, and that a number of those waste are being dumped in outside of the EU. Okay, so in our research, we're really trying to answer the following question. To what extent does EU law and policy effectively address business-related human rights risk during the life cycle of energy transition technologies? So in order to answer this general question, we have a number of individual research questions. The first one has to do with acknowledgement. To what extent are human rights and environmental risk acknowledged in EU legislation or policy? I should just specify that when we say EU legislation or policy, we are looking at instruments that already exist, but we're also looking at ongoing initiatives and upcoming instruments. The second research question has to do with scope. Which resource or aspect of the value chain or businesses are covered by those instruments? I think that's a very important element to take into account. The third aspect has to do with concrete legal measures. To what extent are there concrete measures to avoid or allow redress for human rights violations and environmental damage? And then the last question, which has to do with overall effectiveness, is how effective are concrete measures in ensuring human rights and the environment protection? So, yes.
Yeah, and I mean, so basically we've split this up into sort of two general areas. The first area that I will describe is kind of how this issue is addressed in sort of the energy policy debate, let's say. And I just show you here. I won't go into detail in all of these because it would take too long. But at the top again, you kind of see the EU Green Deal as sort of a chapeau policy framework, and I put Repower EU because that is sort of supplementing the Green New Deal, or at least complementing it within the new geographical context. And below that, you kind of have these broader, more specific policy strands, which this would be where the acknowledgement comes from. You know, has the EU identified that this issue actually exists, and what does it sort of plan to do about it? And then at the bottom, this is where the rubber hits the road, so to speak, and looking at the actual specific legislation. So far, what we have looked at, what we have uncovered is that a lot of the regulations that pertain to energy transition technologies have focus around eco-design and labeling. And basically these are standards. These are standards that are required on manufacturers, producers of their products to make sure that, you know, for instance, they are recyclable, that consumers have information about what to do with them when they're finished, to extend their lifetime. And some of the eco-design elements are now, it seems that the EU wants to focus more on the human rights impacts. For instance, in PV panels, they have indicated their interest to impose a restriction on the entering into the market of solar panels that were used with slave labor, for instance. There is a battery regulation coming that is being developed at the moment. And this focuses on downstream and even upstream in terms of the sourcing of minerals and the legal requirements that they have to do, that they have to abide by, in making sure that their supply chains are not on the wrong side of the line, I guess I would say. But a lot of this has taken place in sort of sector specific areas. The major gap that we've seen so far is with ICT, also known as information and communication technologies. This is kind of the glue that will bring all of these renewable energy technologies together so that they can further the energy transition without going into all of the detail. The sun doesn't shine all 24 hours. The wind doesn't always blow. So you need to be able to match, match consumption with production. And a lot of that requires flexibility. And so in order to be able to integrate these resources safely and efficiently, you need smart technologies, smart grids, this type of stuff. And all of that uses ICT technology. There are requirements for this, but it mostly has to do with personally handheld devices like solar, like phones and iPads and tablets and all of this stuff. But when it comes to smart meters or other smart technologies, this is a really big gap. Which is somewhat concerning because they take a lot of, in particular, special types of resources, but they also are very hard to recycle. So it's kind of a big problem.
Joshua, can I ask you please to wrap up?
I'm done with this slide. Yeah.
So I'm supposed to basically present the instruments that or initiatives in the field of business and human rights that are relevant to addressing human rights and environmental risk in the clean energy transition. So I just focused on like a different instrument that in the field of disclosure and due diligence, because due diligence is a very hot topic at the moment in the field of business and human rights. So I'm not going to mention this. I'm not going to describe those instruments because we need to wrap up. I would just say a few words about the recently released proposal for a directive on corporate sustainability due diligence. I think it was a few months ago, in February, I think, the European Commission released a directive that will require certain companies to conduct due diligence to avoid actual and potential human rights and environmental adverse impacts in their operation, the operations of their subsidiaries, and their value chain operations. So that's a very important instrument in the field of business and human rights at the moment. There's a lot of attention about this, and actually this instrument will be directly relevant to address the issues we mentioned before. Assessing this proposal from the different perspectives that I mentioned earlier, what we realize is that there is no direct acknowledgement of business, of human rights and environmental risk associated with companies. It's unsurprising, actually, but the proposal basically talk about the involvement of companies to achieve EU environmental objectives in a positive manner. There is no really like in the document explaining the proposal, there is no really mention of the role of companies in the clean energy transition. So you will say, yeah, but that's not surprising. It's a general directive, but actually there are mention of the European Green Deal and the role of companies in the EU's transition to a climate neutral and green economy. But it's really mainly focused on the obligations of companies in relation to climate change, as opposed to obligations of companies when they are implementing the green transition. So I wanted to mention this. I'm going to hurry. I see that I need to wrap up. I'm just going to focus on effectiveness here. The scope of the proposal is quite broad, which can be a good thing, actually. It's not limited to specific resources. Companies have to actually look at the actual and potential human rights and environmental adverse impact in a very broad manner. But so there are the companies have to perform due diligence in the context of their operations, the operations of their subsidiaries, and in their value chain operations. So that's quite broad as well. However, if you look at it from an effectiveness perspective, what you realize is that actually the number of companies that will fall under the scope of the directive is quite limited. If you look at it from like a value chain perspective, you see that there is an excessive reliance on contractual assurance to ensure that due diligence is performed, and this is seen as a limit. And one thing that is positive about the directive is that it has provisions on civil liability. It imposes a civil liability regime to hold to account companies that fail to perform due diligence and then the failure of performing due diligence leads to damage. But the problem is that there are complicated rules on civil liability for damages caused by indirect partner in the context of value chain operations. So that could really limit the perspective of access to justice in the context of human rights abuses or environmental damages taking place in the context of the clean energy transition. So we'll stop here, and sorry for taking more time than I should have.
Thank you very much. Thank you, Josh and Virginie, for this presentation. So now let's finish, and sorry very much, apologies for our two last speakers who are working at the partner institution organizing this webinar. So it's Canella Witt and Laura Duarte Reyes. that will give us a practitioner perspective on corporate accountability for human rights abuses and environmental damages, focusing on transnational legal remedies and prosecutions. Very rapidly, Canella Dit is co-director of Business and Human Rights at the European Center for Constitutional and Human Rights. After studying in France, Canada, she worked for several local organizations in Brazil and Mongolia, focusing on socioeconomic rights. Then she worked on Human Rights Watch on the trial of Hissène Habré. A doctoral thesis looks at the protection of whistleblower under asylum law. Laura is Bertha Justice Fellow in the Business and Human Rights Program at the European Center for Constitutional and Human Rights. And during her studies in Colombia and in Italy, she worked in strategic litigation in support for the Colombian peace process. After that, she was also legal advisor for the implementation of public policy and public-private partnership, and provided legal support to human rights organizations in the field of women's rights in India, Colombia, and Italy. So, sorry again for the limited time that we left to you. Canella, Laura, please, the floor is yours.
Yes, thank you very much. I will start, and we will keep it brief, shorter than what we had planned, so that there is, I don't know, a little bit of time for questions, maybe. So in the Business and Human Rights Department at the CCHR, what we do is that we develop strategic litigation in support of individuals or communities that are affected by corporate transnational harm. And in my little input, I think I'll focus on giving an example of a litigation that has been so far quite successful in the field of business and human rights in armed conflicts. So I'm going to speak about the Lafarge case, which is a case that, so very briefly, the facts from 2012 to 2015, a French cement factory, Lafarge, that had acquired a factory in the northeast region of Syria, decided to continue its activities in Syria as the civil war was basically raging at its doorstep. And in order to do this, in order to continue maintaining its factory running, it decided to get into agreements, financial and commercial agreements with armed groups that were active again around its factory. Investigative journalists have revealed in 2015 that those financial agreements had led to roughly an amount of 13.5 million euros that had been paid to intermediaries of armed groups, including ISIS, that were again active around the factory of Lafarge at that time. So ECCHR and our partner Sherpa in France, together with 11 former employees of the company in Syria, have filed a criminal complaint in France against Lafarge as a legal entity, because this is a possibility under French criminal law to file criminal complaints against legal entities and not only individuals, corporate executives. And in that complaint, we have argued that Lafarge had been should be investigated for the financing of a terrorist enterprise, for endangering people's lives, namely its employees in Syria, and also for complicity in crimes against humanity. So that was in November 2016. 2 years later, Lafarge was indicted, charged for complicity in crimes against humanity by the investigative judges. And Lafarge contested this charge, saying that it had, it accepted that it had financed ISIS and other armed groups, but it was doing so, according to Lafarge, in order to maintain its commercial activity going, which meant, again, according to the company Lafarge, which meant that it couldn't show the intent that is required to characterize complicity in grave crimes or in crimes against humanity. So an appeal court in Paris in 2019 decided indeed to cancel this indictment for complicity in crimes against humanity, based on the mere argument that in order to be accomplice to a grave crime, one not only needs to know that it is contributing to crime, but also needs to share the intent of the main author. So this relates a bit to previous presentations that we had on this panel. And so what we did is that we went to the French Supreme Court, arguing that under French criminal law, in order to be accomplice, one only needs to be facilitating the commission of a crime, without having to share the specific motivation, or the specific intent of the main author. And in last September 2021, the French Supreme Court gave a groundbreaking, I would say, ruling for the field of criminal corporate accountability, because it welcomed our arguments, and it said that the reasoning of the appeals court to cancel the indictment on complicity in crimes against humanity was not legally founded, because, according to the Supreme Court, in order to be an accomplice, one does not need to share the intent of the main author. And the court went even further by saying that pursuing a commercial activity does not exonerate oneself from criminal liability for complicity, because should that be the reasoning, this would lead to impunity of many crimes that we know are committed, sometimes with the contribution of economic actors. So that's for the complicity, basically for the interpretation of complicity in crimes against humanity. And I also wanted to mention briefly in terms of attribution of criminal liability to parent companies for actions or crimes committed by their subsidiaries, that the company Lafarge is also charged for financing of a terrorist enterprise, although the payments were made by its subsidiary in Syria, so from the accounts of the subsidiary in Syria. And the company is also charged for endangering its employees' lives, although its employees were employed by the Syrian subsidiary. They were working under Syrian labor law. And the appeals court had found that in order to attribute criminal liability to the parent company for the actions of the subsidiary abroad, one needed to show that there was a control, financial or operational control of the parent company over the subsidiary. And therefore, the conclusion of the appeals court has been that the parent company is funding or is owning almost fully at 90 and something percent its subsidiary in Syria. It is also involved in the decision-making regarding the safety of its employees. And it also exercises a certain operational control over its subsidiary, which, according to the appeals court, shows that the subsidiary has lost its autonomy in decision-making, and therefore the criminal actions of the subsidiary can be attributed to the parent company. Yes, I could have spoken a little bit about the EDF case, but I think we have Laura who is going to speak about also cases related to environmental damage. So I leave it to you, Laura.
Thank you very much, Canel. So I would also try to be very brief. And what I wanted to share with you today is an example, a legal intervention that ECCHR, together with our partners in India, has started in Switzerland against an agrochemical company for the human rights impacts of pesticides use. And I think it relates also to some of the discussions we have had today, because it is representative of the challenges that we as practitioners face when litigating these cases transnationally, both in terms of evidence gathering and also in terms of attribution of responsibility to mother companies. So at ECCHR, we have been pursuing different legal actions on pesticide use for the past years, and we have mostly focused on the right to health. However, recently we have also started to explore alternative legal avenues to tackle the environmental impacts of intensive pesticide use, which are related to biodiversity loss and ecosystem degradation. So the case I will focus today on is related to the responsibility of the Swiss company Syngenta for the poisoning of Indian farmers with one of its products, the pesticide Polo. And it has been a particular legal intervention because we have decided to start two parallel proceedings, one in front of the civil law, the civil courts based on product liability laws, and the other one in front of the OECD National Contact Point in Switzerland. So the facts of the case are that in autumn 2017, hundreds of farmers suffered pesticide poisoning in the district of Yavatmal in Maharashtra, India, And after research done by civil society organizations, it was concluded that the people who had been affected, that had adverse health effects, had been exposed to different pesticides, and one of them being the product Polo. And this product, which was produced by the Swiss company Syngenta, contained an active ingredient which is called the diafenthiuron, and this ingredient had been banned in Europe due to its effect, to its negative impacts on human health and the environment. So it was found that Syngenta marketed the product despite knowing that first, it had been banned in Europe for these negative impacts, and second, that most farmers in the region were unaware of the dangers associated with pesticide use. So when analyzing which also one could use to hold Syngenta accountable for this damage, there were several options on the table, and the idea was to find an avenue that could lead to first access to justice and second remedy for 51 farmers. The first option to be analyzed was a civil claim to ask compensation from the company based on product liability. And here we start to find and see the first challenges related to evidence gathering, because documenting cases of pesticides poisoning in rural India proved to be extremely difficult. So farmers rarely keep purchase invoices, so it was really difficult to prove that they had been exposed to that particular pesticide. So the causality question was also difficult to overcome. And the same is true for loss of earnings or loss of income, because the income is generally not documented, and payrolls are unusual practice in rural context. So this type of documentation, which is essential to claim compensation in a civil lawsuit, as you can see, was not available, and this already shows how this hinders access to justice. Is one of the greatest obstacles for access to justice in these kind of transitional cases. So after analyzing several documents and evidence, it was found that only 3 people actually qualified to be claimants in the lawsuit: one survivor who had long-term consequences, and the families of 2 people who had died. So only these 3 people were part of the civil complaint, which is at the moment ongoing in Switzerland, and it's at the admissibility stage. So after this decision was taken, then there were other 50 farmers that still wanted to claim damages or get remedy for the harm that had been caused to them. So the idea was to file an OECD complaint on behalf of the 51 affected families, together with PAN, India, Public Eye, and Maharashtra Association of Pesticide Poisoned Persons. And this complaint was filed in September 2020, and the National Contact Point of Switzerland accepted the complaint. There was the risk that since there were parallel proceedings, the National Contact Point would not declare it admissible, but it was. And the company accepted to enter into a mediation with the claimants. So here it was feasible, first because in civil lawsuits in Switzerland, there is no class action, so it was hard to also bring a group of people together to claim for damages, but in the OECD proceedings, it was possible. And second, the threshold for evidence in the specific instances in front of the national contact points is much lower, so it was possible to present their case without having to provide all the evidence that was not readily available on the ground. So what the claimants were arguing in the OECD complaint is that Syngenta had marketed the pesticide knowing that farmers were not aware of the risk, and they were not using the equipment that was needed to protect themselves. And they asked the company to change its business practices and also to pay for remedies, so financial compensation, which is very rare in OECD proceedings. So the case is still ongoing. As I said, the company accepted to enter into a mediation, and what has been discussed during the mediation is covered by confidentiality rules, so that's something we cannot share. But what I can say is that the proceeding is arriving to its final stage, and as in many other cases, the expectations of the claimants have not been always met during the mediation proceedings. So here you can see that although there have been many developments in relation to business and human rights and the ways in which corporations can be held accountable. We still face several obstacles also at the procedural level that then hinders practitioners and victims also to access a further stage where the merits of the case are actually decided. So there is still a long way to go. And with that, I finish my presentation. I see, Ivano, you are back, and thank you, everyone.
So, hello, everybody. And sorry that we can't be in the same room in person, and sorry to add to your time another 30 minutes of online. For those of you that I know, pleased to see you again, and for those of you that I haven't met yet, pleased to meet you. Here's my promise with you, because it's been extremely intensive, and I don't know about you, but my brain is full of amazing ideas. The last panel was very astonishing, so thanks for your presentation. So what I'm going to do is not to go into technical ideas, but instead share with you some more personal reflection. And I'm not going to go into any specific case. I just want to have a critical review. So for those of you that maybe know me and have seen me before, you might be surprised, but I'm going to be very critical of human rights. I've been an advocate of human rights law, having a role in natural resources for the last 15 years. And it's not that I'm losing faith, but I want to share with you some doubts in the hope that you can help me to remain more faithful towards human rights law. So why am I losing a bit faith? So that's why I'm going to look at what is my critical approach, if you want. So I'm going to be critical on two elements. First, I'm very critical on the space that human rights law hasn't managed to grab. What I mean by this, the broad area of natural resource governance, which is very broad, as we've seen today. Human rights law hasn't yet managed to really be a force in there. It's still dominated by other areas of the law. So first, I want to be a bit critical of this, and then I'm going to also be more critical on the role of accountability. And we have this definition that we looked at earlier on. So I'm going to be critical, but I don't want. But anyway, this is the way I'm coming from. And you see my title, which is more personal. I'm coming from a very optimistic vision when I started to work in this field 15 to 20 years ago, to being quite skeptical about it. I just want to place aside as a personal level why I became so skeptical. My research has been covering two angles, the classical, more, let's say, academic research, where I've been trying to explore the role of human rights law when it comes to natural resources, but also in the UN circle, where I've engaged with advocacy. And I just put an example there, for example, as the new general comments on the right to learn, which is coming from the Committee on the Economic and Social and Cultural Rights, which we started 10 years ago to work on, and it's finally being adopted. So just an example, but I had a few initiatives like this at the UN level, trying to push for the space for natural resources. And that also led me to be quite skeptical on the capacity of UN human rights institution or mandate holders to really to make an impact. So that's one element. The other element that I'm going to look at is the litigation. An important element of my academic activist engagement has been to support litigation, especially indigenous people's litigation, trying to bring natural resources and human rights element into the cases. I've done that at many levels, as an expert witness in front of the Inter-Market Court of Human Rights or the African Commission and the African Court of Human Rights, but more recently in a national setting when I'm supporting cases of litigation in Namibia, but also working in Malaysia. I could go on the list, but it's just to say that this is the two angles that I'm coming from, is the academic / advocacy research at the UN level and the litigation engagement supporting especially indigenous communities when they claim their right to land and natural resources. So why did I lose my optimism? First, on the place of human rights law in natural resources governance, sadly, I don't think this human rights law hasn't really managed to become more significant. What I mean by this, I think we've used so far in the day, we have used the term natural resources governance as a loose term. I spent a bit of time trying to unpack it, and it's quite, there's no such a field as such. It basically brings a lot of field, and we've already mentioned the fragmentation of international law on this. I think when I wrote the book on natural resources and human rights in 2016, I really felt that human rights law could become an important player in this field. I have to realize that it hasn't. So I'm using that term, I don't know if you see that, my term is using the back door. What I mean by this, all the litigation we talked about today, all the cases you've all mentioned that you're working on, we have to realize that we use human rights elements in processes that are not meant for human rights. So when we try to knock on the door of those investment or trade law or corporate code of practice, trying to say, human rights law should be proeminent. I'm not saying that we are wrong to do that. We are absolutely right to do it, but I don't think we've managed really. And that's really visible when you go into the UN circle, when you go to those meetings, when you realize that human rights law is still seen as something by many states anyway, as covering civil and political rights of individuals. The connection with natural resources governance, I would say, as people on this conference, we are very convinced by this, but outside of this circle, it's not always the case. And I can even talk about the lawyers, the human rights barristers and solicitors, as they call in the UK, or the lawyers I work with. For them, the connection with natural resources governance is not obvious, and they're not really convinced that actually human rights law has a role to play there. Again, it's not that I agree with that analysis, but it's just that I was hoping that human rights law will manage to do a bit more. And to be frank, I do feel that whenever investment or trade law is involved, human rights law is not prominent, but also usually ends up as being a recommendation or finish like as a CSR, but doesn't really become the real game in town. So that's one element that I feel that really, if I look at the architecture of natural resources governance, I would say apart from us on this conference today, it's not there. I've done many courses, I've done 2 conferences on natural resources governance, and I'm sure you have. Human rights law is usually not really the cup of tea that is presented. So this is one aspect. The other element, which I find more problematic, is the content of human rights law. I would say it's still weak, but also it's full of contradiction. So let me move to this, what I mean by the contradiction especially. These are the 4 elements what I feel are the problem with human rights law. And we talked about earlier on about fragmentation, and I will add to this. I would say it's what I call a piecemeal approach, where if we talk about natural resources governance, human rights law is very divided and very specific, and you basically have to be a specialist in a very narrow field. What we are lacking, and that's my first element, is the overall discourse. Which is weird because in a way, the centerpiece of human rights law is supposed to be about natural resources. I will remind you, and I hope we have to keep that in mind, that Article 1 of the 2 international covenants are making the affirmation that peoples have the right to control the natural resources. This is Article 1.2 of the 2 covenants. So it was meant to be really central to human rights law. I've written on this, and really I've looked at the history of this article. It hasn't really been living what it should be. Why? Because sovereignty has taken over, and also because this principle has been totally overlooked by the principle of permanent sovereignty of the states. I won't go into detail there, but just to flag that in a way, human rights law probably was based on an utopia that people should have the right to control and to manage the natural resources in the country where they live. It's very rare that A, it's recognized by government, and 2, implemented, and 3rd, by company, even less when we go to the corporation. So that has become a bit of an utopia. There are many reasons that I don't have time to go to why that has become the case, why this Article 1 hasn't really been embraced by the UN monitoring bodies. But as you can imagine, it has been basically living in the shadow of sovereignty. It has an impact on the whole human rights edifice because it means that then we have to look at very specific, narrow rights to look at natural resources because us as citizens suddenly don't have this overarching right to natural resources governance. So we could also look at the right to development, but I won't go too much there because again, I'm sure we are all aware of the limitation of this right, what it hasn't led to, the fact that nature has many see as a resources, that in most cases have worked, it's the state that used the right to development to justify displacement of local population. So if we take both this meta approach on the discourse of human rights, it has basically failed to really impose human rights as a big force in terms of natural resources governance. Then if we go more into the detail, and I'm not ignoring those details, there are some very important evolution in terms of human rights law, especially in terms of public participation, in terms of transparency of the way governments allocate those natural resources or the extractive contracts with companies. Taxation is supposed also to be part of human rights. There was, and there still is, a big movement that taxation should be connected to the fact that us as citizens should benefit from the exploitation of the natural resources. There was a case earlier on, we talked about 60% of the cobalt come from the DRC. It's clear that the citizens are not seeing any of the money from the taxation coming in their pockets. Just an example, but what I mean there is, despite this angle that are very promising that human rights law will give citizens a right to public participation, an obligation on the states and the corporation to be transparent, and the fact that we should benefit ultimately from the exploitation of natural resources, it hasn't really done any knock on the fact that, as I put there, that profit maximization, that all the different mechanisms put in place by the international financing to profit hasn't been really damaged or even unraveled by the human rights angle yet. The other one concern, and that's my number 3, that I'm a bit concerned, is the fact that human rights will also become very fragmented between the type of people that might have right to natural resources. As I said, I see myself as supportive of indigenous peoples, and I see myself as an ally of their cause and always fighting in the cases. And they've made amazing progress, in terms of natural resources and human rights. There's no doubt that indigenous peoples are leading the way. Without indigenous peoples, the rights, most of the rights that we associate with natural resources won't even be on the agenda. So for indigenous peoples, there's been, at least on paper, a lot of evolution of human rights law, leading to the right to free, prior, and informed consent, to self-determined development, and so to many important rights. More recently, the Peasant Declaration also has made some progress in terms of, opening the space for human rights law to be present in the natural resources governance, but there are limitations with this declaration that I'm happy to talk about maybe later. But what's lacking, we could go on, you see what I mean? There are specific groups that might have specific rights, but the fact that all of us, all the citizens should have a say in the natural resources governance as promised in Article 1 of the two covenants is not yet there. And there's when you say that citizens have that right, usually it's not something that comes under human rights law. So there is a danger that it will become even more fragmented with certain group having certain rights, but losing the fact that all of us as a human, we have a human rights to natural resources governance. The fourth point when I find the weakness is we are trying, all of us, I think in this conference and beyond that, to use human rights law for accountability, for corporate accountability. I won't go back to what we talked about earlier on, the slow progress that was led to, and the elusive promise that maybe we'll get a treaty. But what I find striking is that instead of the language of human rights, we have to be very creative to use other languages coming from tort law, from civil liability, basically due diligence, and etc., which is fine. We're moving, we're using other rights, but it's not, we should actually be able to use human rights law. We are not able to, so we have to use something else. So I find that, in a way, we are diluting this language of human rights to make it different. But in doing that, we're also sort of losing the idea that, all of us as citizens have said we have the right to natural resources governance. So I'm not saying that I'm, again, losing faith in human rights, but I'm sharing with you some of why I got to a point where I'm starting to feel that human rights law hasn't managed basically to come to the front door. It's still in the back door and diluted in all those different battles. And also maybe to join the discussion we had earlier, I think the danger is basically it becomes so fragmented that all of us have to become so specialized in one of these fields that we are losing the overall picture. Now I want to illustrate, that's my second point. It's like, okay, maybe this is fine because I'm talking at the theory, to what extent human rights law in theory could protect or to give us a space as citizen to have access or to control natural resources governance. But now I want to zoom into the practice. And here I'm sharing with you the last 15 years where I've really got engaged in litigation supporting indigenous people's rights. The picture you've got, it's a report that we did looking at the impact because you might be familiar. I'll give you an example. I've been involved in 2 cases that are used in textbooks that are cited by students. The Ogek case in the African Court of Human Rights in 2017, important victory by the Ogek, and I could cite the other 15 cases of the Inter-American Court of Human Rights that are in all the textbooks on victory for indigenous peoples. But what we did with this study, we look at those cases. They are fantastic, and don't get me wrong. Decision, they really pushed the law. It was very important for the communities, but implementation has been close to ground zero. What I mean by this, the land hasn't been returned. There's been no compensation to the communities. They still live in shantytown on the margin of their land. They're still not included in any political process. And that includes all those cases. There's very little actually to show in terms of human rights law when it comes to implementation. If I'm a bit even more skeptical, it's very nice for the lawyers or people like me because we feel that we've achieved something amazing by pushing the border of human rights law by getting those decisions. But on the ground, it's quite different. So I'm always a bit more skeptical with citing those cases that are beautiful pieces of decision making, but they are lacking the fact that I wish I could say the Ogek won the case in Kenya in 2017 and their land and their forest is back to them and they are in charge of the forest. None of this is actually real. So this is why you can see what I'm getting a little bit less optimistic. But also the problem I have with those cases is behind those cases often are the corporate worlds. But because we have to use the regional human rights system, we are going against the states. The corporation get away from it. There's a case I'm involved at the moment in Colombia that you might have heard about because it's a big one that concerns is the Awa community that are taking on the big oil companies. Again, the case is against Colombia because we cannot really go on the corporate sector. And in a way, the corporation are manipulating the states to act on their behalf, and they hide behind, and the corporation, as we said earlier, are able to play those games. Worse than that, and this is my point here, what I mean, there's 3 points in practice. There's been more and more development, more technical areas that have been developed that make it extremely difficult for communities to take legal action. But also what we've been witnessing in especially the last 5 years, is an increase of threats. The community members being threatened if they dare to take a legal action against a development taking place on their lands. And often this is doubled up with delaying tactic by either the governments or the corporation. What I mean by this is taking other different legal cases, harassing the people, or saying that there are issues with the way they're paying the taxes, the way the NGOs that have been financing the case, but also I'm sure you came across this idea of the SLAP, so the strategic lawsuit against public participation. So what I say, it's a double thing that we see. It's a more violence on the ground and real threat to people's life when they dare to take legal action, but also they are facing litigation against them because they dare to take a case of litigation. And that has really been increasing massively. Why? Because corporation, but really the investors are getting much more savvy as using delaying tactic and legal methods to stop those cases, knowing that eventually they will lose those cases. But it's not about that. It's gaining those years. And those cases that I'm mentioning, they are between 5 to 10 years in the making. In the meantime, the land has been exploited, the profit's been made, the corporation are basically making the profit, but also changing the way the structure is done. So you're taking it against a corporation, but by the time that corporation is not even the same corporation, it has been resold, it has been merged into another one. So you're not anymore reactive. So this is one of the issues I find with human rights, using human rights law, at least in litigation. It's a very, very slow moving beast. I don't know what I'm doing in time, but I want to close this because I don't want to give you the wrong impression that I've given up, that I don't want to do those cases anymore, and that I don't think human rights law is relevant. Quite the opposite. So I think the way I'm trying to move is to move to a positive skepticism. So let's say maybe a few years ago, I was very optimistic that human rights law will become a key factor in natural resources governance, that those key elements of public participation, transparency, benefit sharing will become the way to drive it. It hasn't been the case, so it doesn't mean that it's the end of the game, that we still need to fight. And everything that we've looked at in the previous panels, is very encouraging because it's all those things are shaping and going to the right direction. But at the same time, I basically turn myself to you because I need to remain optimistic. So I need to still see that human rights law is still the right way. The way I put it to my students these days is like, well, maybe, you might be a better human rights advocate if you do investment and do a master's in investment on arbitration, because that might be the way where we need to really fight the battle. So instead of, and I put it that way, which is, could we move from the back door to, to the main entrance? What I mean by this, we need to not anymore have human rights law that comes as an add-on to the corporate world, when it's like they will add as a sort of a greenwashing. We have the human rights washing, which is, you add in your CSR some human rights elements, you do some reporting and etc. to something which is much more at the front. So yeah, I don't know. I hope it makes sense. Want to open the floor because really, it's, as I said, it's not a technical presentation. It's more trying to reflect on what is the role of human rights law in all this. And again, I'm not dismissing that business and human rights is evolving as we speak. It's a very rich field. But despite all the cases we mentioned, and we mentioned the OECD guidance and etc., for me, it hasn't yet on the ground. I haven't seen a community that come to me because there was a question earlier on can you show cases where someone actually won and they got the land back? I've been asked that question many times from indigenous peoples. Like, is there a case that can say, I don't have the answer? There's never been a case that we said they won the case, they got the benefit sharing from the corporation, the development is going on, and it's actually a good story to tell. They are never, there's always some small victories, but in the grand scheme, it has not been the case. So sorry to be quite pessimistic at this time of the day, but really it's more to put a bit of oil on the fire to see how you will react. Thanks for your attention.